Hearing in the building Armstead against Royal Sun Alliance Insurance Company Limited.
Yes, Mr. Williams.
May it please your Lordships, your Ladyship, I appear for the appellant with my learned friend Mr Ben Smiley. My learned friends Lord Marks of Henley-on-Thames, KC, and Mr Quentin Tannock appear for the respondent. The respondent is, of course, Royal and Sun Alliance Insurance, which is the negligent driver, Mr Galazowski's insurer, not itself the wrongdoer, because implementing the EU Motor Insurance Directive, English law gave Ms Armstead direct recourse against RSA. To avoid needless refinement, I don't intend to distinguish between RSA and the wrongdoer unless it's necessary to do so, and I rather doubt that it will. So if I refer to the wrongdoer, I'm not trying to draw a distinction between the insured and the insurer. My lords, my lady, the issue which arises, as you know, is whether a person in possession of hired goods...
Would you just sit
yes.
here for a moment? Yes, do carry on.
Thank you. The issue is whether a person in possession of hired goods which are damaged in an accident caused by a third party can recover a resulting contractual liability to the hirer as part of her claim against that third party. And the claimant, who is here the appellant, says that she can, where the loss resulting from the contractual term is foreseeable, one aspect of foreseeability being that the liability it imposes on the claimant is not unreasonable. Here, Mrs Armstead says the liability claimed was indeed foreseeable, was not unreasonable, and therefore should have been awarded. My lords, my lady, I propose to address matters as follows. Firstly, a summary of the relevant facts, which in this case I hope can be extremely brief. Secondly, to analyse the significance or other...
Sorry,
not
my screen's not working. We are listening.
I'm glad that the gremlins don't just affect the bar. So I'll just continue unless yes. You want me not to. So secondly, analyse the significance or otherwise of the fact the claim is made in respect of a vehicle on hire to the claimant, what might loosely be called, because it's how it's put in the case, is the bailment issues. In short, we say that factor is really immaterial. The claimant had standing to bring the claim, in the same way as any claimant who suffers property damage, because we say the law treats possession and ownership of chattels as one. But so bailment goes to locus, which we have, and we say that thereafter it's the law of negligence and not bailment that determines whether the claimant can recover her liability to the hire company from the wrongdoer. Thirdly, therefore, I will address what I say is the general position in negligence. And as to that general position, we will say it's clear. The defendant owed a duty to take care to fellow road users such as the claimant, which was breached, and it could readily be foreseen that by damaging her property, she would be caused financial harm, which might include liability to a third party under a pre-existing contract. So the outcome of the case, we say, in truth, turns on the next issue, the fourth issue, which is whether the specific loss here resulting from the contract was a reasonable one. And as part of answering that, so was clause 16 of the contract reasonable? We say it was, and therefore the liability is recoverable. The fifth point...
Not really a point of law at all, that, let alone one of general public importance.
Well, if my analysis is right, that might be so, but as Lord Justice Dingerman's analysis, if that's right, then whether or not that's right is perhaps the important point of law.
Exactly.
Yeah, yes. Fifth, the so-called basic hire rate evidence. I apologise for using the jargon of these cases. Basic hire rate evidence that has been placed before the court, not before the lower courts. I'll address that very briefly. We say it takes them nowhere. There has been an exchange of notes about this very recently, with a certain amount of procedural wrangling about the appearance of that evidence. I very much
take time up front of resolving the procedural wrangling. We've looked at the material, and we will, as it were, de bene esse, and we'll read and hear what you have to say.
I'm very grateful.
And conclude as to it in our judgment.
I'm grateful. It's certainly not an issue on which I propose to dwell, but I'm very grateful to the court for that indication.
There's quite a lot on the agenda.
Yes, there is.
Without taking time up on
I'm afraid that there is. And then 6, if time permits, and as a cross-check to our primary position, just to examine it against the 6 questions identified by this court in the Meadows and Khan and Manchester Building Society and Grant Thornton cases. I don't know if the court has seen the recent practice note from the heads of division in the lower courts called encouraging greater participation of junior counsel. But in fidelity to that note, if time permits, I'm going to ask my learned friend, Mr. Smiley, to follow on that point. Really, as your lordships would appreciate, that's principally a ruse so that for at least 10 minutes or so of the case, my clients are competently represented.
We're delighted if either or both of you take that course.
I'm grateful. So if I can start with the facts, despite what I perhaps should begin by saying is despite statements by my learned friends to the contrary, this case isn't really part of, or is only peripherally part of, the so-called credit hire litigation. And the reason for that is this. Although in the 16th, no, I think more precisely the 17th and 18th centuries, the common law moved away from imposing a strict rather than fault-based liability on bailees for borrowed goods, it remains the case that that position is often reinstated by contract, and in no sense is that particular to credit hire companies. And if I can just broaden it to car hire more generally, I would surmise it's likely that even amongst your lordships and your ladyship, there are people in court today who will have experienced what might be called the start of holiday ritual of walking around the hire car at the airport, taking note of any dings or scrapes before you drive it away, often with the hire company frantically trying to upsell you additional insurance. And it's one of those things where you look nowadays and you think, gosh, how on earth did we manage before we had cameras on our mobile phones? So the attraction of reinstating the old strict liability to companies which rent out property, be it short-term or long-term, is obvious. Their valuable asset is outside their control. It's outside their line of sight. They want it reinstated to them in good condition. If it's deteriorated, they don't want to debate the issue completely outside their knowledge or ability to verify of who is to blame for that. And although in this context, the issue arises in the context of short-term hire, we say there is no reason to suppose the same issues would not arise in the context of vehicles subject to leases or personal contract plans or hire purchase arrangements, or other forms of hire altogether, such as a hire of plant or machinery or furniture or other sorts of equipment. Now, the hire agreement in this case, using the PDF numbering in the main bundle, is page 188. That's going straight into but the small print with which we are concerned is at page 189. The terms are in 2 columns, which is not the best for viewing on an electronic device, I appreciate. So starting with the left-hand column, if I can invite attention to clause 14, which is towards the bottom. Clause 14 says you must return the hire vehicle in the same condition as it was and with the same accessories and equipment as it had at the start of the hire, and even if there's a policy of insurance covering such loss, shall, subject to clause 15, which I interpose to say is about collision damage waiver, indemnify and pay the lessor, that's the hire company, immediately on demand for any loss or damage to the hire vehicle. And then there's some specific provisions about smoking and such like, which I won't get into. And then if one goes to the top of the adjacent column, it's at clause 16 that we have the key clause for present purposes. You will on demand pay to the lessor an amount equal to the daily rental rate specified over leaf, up to a maximum of 30 days in respect of damage for loss of use for each calendar day or part of a calendar day when the hire vehicle is unavailable to the lessor for hire because you have not returned it in accordance with, it says clause 9, or the hire vehicle has suffered a mechanical failure except where you've complied with clause 22, or the hire vehicle has been damaged. Following damage to the hire vehicle, clause 17, for which you are liable under this agreement, you will on demand pay to the lessor such sum as in the lessor's opinion, acting reasonably, represents the diminution in value of the hire vehicle. And then if one just goes down to clause 20, the court will see there's also provision for there to be a £50 plus VAT administration charge where the hire company needs to deal with the damage claim. Not suggesting that all that much turns on it, but just again to place this into context, the uncontested evidence is that conditions like this are in fact common in car hire agreements and not just credit hire agreements. And just for completeness, if one goes forward to page 204, the court will see the standard terms and conditions of Avis, which were in evidence below. That obviously is one of the household name conventional car hire companies where you pay up front. The sort of car one does circle at the airport with one's camera on. Clause 6 of that agreement, which is in the right-hand column, bottom end of it, drafted in the American style, renter will pay the following charges. And then I think we can probably skip over to the to E, F, and G on the left-hand column of the following page. As E, on demand, the full cost of repairing or replacing the vehicle if it's damaged or stolen, even if it's not the renter's fault, plus in that case a £66 plus VAT administration fee. And then F, on demand, a loss of income charge. Avis will charge renter at the contracted rate if it cannot rent out the vehicle because it needs to be repaired or is a write-off, and Avis is waiting to receive full payment of the vehicle's value. Avis will do everything it can to make sure the vehicle is repaired or gets payment as soon as possible. Avis will never charge renter for more than 30 days loss of income. So there's obviously a fairly straight parallel to the instant case. And lastly, there are terms from another car hire company as well, but it's overkill to show the court all of them. I'll just show the terms of Thrifty at page 206. And they begin. That's obviously another well-known conventional hire company. And if one cycles through those terms to page 211, in the middle of 211, there is a subsection numbered 7, charges. And then at E, you'll see they impose on the renter the cost of repairs, whether or not the renter was at fault. And then at F, a loss of income charge when we demand it if we cannot rent out the vehicle because it needs to be repaired, if it's a write-off, or if it's been stolen and we're waiting to receive a full payment of the vehicle's value. G, we will only charge you for loss of income if we cannot get back our losses under the damage protection programme as explained in section 8. We will charge you at the published daily or hourly rate, and we will never charge you for more than 30 days.
It's in the statement of, it's an agreed fact in the statement of facts and issues that this is in its structure, a common clause.
It is, and if I've labelled it, I apologise. Obviously, we are at some point going to just get into issues as to whether or not this is something that might have been foreseen, and we say...
Oh, yeah.
As a matter of interest, I don't think it has any effect on the legal analysis, but would I be right to assume that the claim be brought by help hire using the name of Miss Armstead?
I think that's a safe assumption. I don't think it's formally in evidence, but it certainly is the case that help hire has a contractual right to recover its losses using the name of its hirer.
Yeah.
I didn't take you to that contractual right, but it is back in the agreement we visited a few moments ago. So that takes me then to my second set of issues, which is the points around bailment. It's common ground that the fact the claimant was in possession of the hire car means that she was entitled to sue for its repair cost. That went wrong before the Deputy District Judge, but it was afterwards conceded. But that is the extent of the concession. And my learned friend's written case says, without turning it up, they cite the Winkfield, which I'm going to come to, and they say it follows that by virtue of possessory title, Ms Armstead can claim back the cost of physical repair from the negligent stranger, but the Winkfield is not authority for the proposition that she's entitled in bailment to recover anything more from him. And as I say, our submission really is that whole thing is really a chimera. We're not talking about recovering things in bailment. We say the answer to this case simply lies in negligence. But because that point is taken, and because also Lord Justice Stingerman's really seemed to say, for example, with his points about you have to treat, it's not how he expressed it, but he essentially says you treat as res inter alias acta anything between the bailor and the bailee. It's because of that that I'm dwelling on this point, even though it's my submission that it really is of peripheral, if any, relevance, save as to locus standi, which is conceded. But if I can invite your lordships to the Winkfield, that's at page 902. The leading judgment is given by Sir Richard Collins, Master of the Rolls, as he then was. My lords, my lady, the claim in the Winkfield was brought by the Postmaster General following the loss of a vessel called the Mexican, which was carrying mail from South Africa back to the UK. The Postmaster General's claim was for the value of the lost mail, of which he was the bailee. And that was the only claim with which the case was concerned. So the whole focus of the case was on the standing of the Postmaster General as bailee to claim for the loss of value of the bailed property. And I say that's important because my learned friends, with respect to them, seize on references to, oh, he can claim the value of the goods, really to say, well, that carries with it a limitation of the principle. But we say it does no such thing. The Master of the Rolls refers to the value of the goods because that was the thing that was being claimed. But he's not intending in our submission in any sense to trammel what we say is a general principle. So, my lords, my lady, the argument centres on whether the ability of a bailee to recover from the wrongdoer rests on a prior liability to the bailor, so that in effect the bailee really is just claiming an indemnity. And that argument is decisively rejected. And if I can take it up in the judgment of Sir Richard Collins at page 914. I appreciate that this is likely to be a familiar case to some members of the court already. So at towards the foot of 914, there's a paragraph that begins, it seems to me. It seems to me that the position that possession is good against a wrongdoer and that the latter cannot set up the jus tertii unless he claims under it is well established in our law and really concludes this case against the respondents. And he then says that he's going to demonstrate that with reference to authority.
Sorry, where are you?
Forgive me, my lords. The bottom of page 914 of the bundle, starting at a paragraph that begins, it seems to me.
Oh, I'm sorry. My thing has jumped to the wrong page. Yes, thank you.
Thank you. So I just read the first 4 lines of that, which I won't, and then I was going to jump forward to half a dozen lines up from the bottom of the page. It follows that he, that's the Postmaster General, can equally recover the whole value of the goods in an action on the case for their loss through the tortious conduct of the defendant. I think it involves this also. The wrongdoer who is not defending under the title of the bailee is quite unconcerned with what the rights are between the bailor and the bailee and must treat the possessor as the owner of the goods for all purposes, quite irrespective of the rights and obligations as between him and the bailor. Can I just pause there also so I don't need to come back to it to recognise this? That is the passage that Lord Justice Stingerman relies on for his theory that I have called his res inter alias acta theory, that anything as between the bailor and the bailee is just a matter to which the law turns a Nelsonically blind eye. In our respectful submission, whether that's right or wrong from first principles, it doesn't draw any support from this statement of Sir Richard Collins, because he's the only points that Richard is addressing, the Master of the Rolls is addressing, is the question as to whether or not the bailee's ability to recover is founded on his liability to the bailor. And the Master of the Rolls says, well, no, it's not. He has his own ability to recover, and we're not interested in whether or not he owes obligations to the bailor. So that's the context in which the Master of the Rolls says this. He isn't, in our respectful submission, enunciating the principle which Lord Justice Stingerman's extracts. My lords, my lady, if I can take it back up at about the halfway mark of this page, where the Master of the Rolls says it cannot be denied that since the case of Armory, not to mention earlier cases from the yearbooks onwards, a mere finder may recover against a wrongdoer the full value of the thing converted. That decision involves the principle that as between possessor and wrongdoer, the presumption of law is, in the words of Lord Campbell, that the person who has possession has the property. In the same case, he says, I'm of the opinion that the law is that a person possessed of goods as his property has a good title as against every stranger, and that one who takes them from him, having no title in himself, is a wrongdoer, and cannot defend himself by showing that there was title in some third person. For against a wrongdoer, possession is title. And then there is a reference to another case, and the Master of the Rolls continues himself. Therefore, it is not open to the defendant, being a wrongdoer, to inquire into the nature or limitation of the possessor's right, and unless it's competent for him to do so, the question of his relation to or liability towards the true owner cannot come into the discussion at all. And therefore, as between those two parties, full damages have to be paid without any further inquiry. The extent of the liability of the finder to the true owner not being relevant to the discussion between him and the wrongdoer, the facts which would ascertain it would not have been admissible in evidence. And therefore, the right of the finder to recover full damages cannot be made to depend upon the extent of his liability over to the true owner. And again, so firstly, that establishes what we say is a general principle, that the possessor of goods is treated as their owner for the purposes of bringing a claim, as in this case, in negligence. And secondly, I say it reinforces the observation I made a few moments ago, that really Sir Richard Collins's analysis is not in any sense directed at the res inter alias acta type principle which Lord Justice Dingemans pronounced. My Lords, my Lady, just for completeness, I was also going to show you a passage from page 920, which...
I mean, the ratio of the case is in the few words, as against a wrongdoer, possession is title.
Yes.
That's what it decides.
Yes, quite. And those are, in fact, that's the very passage I was about to take the court to at page 920. So if one goes to about the 1/3 mark, the 2/3 mark of the page, there's obviously it doesn't have marginal lettering to help me locate passages, but there's a statement against the root principle of the whole discussion is that as against a wrongdoer, possession is title. The chattel that's been converted or damaged is deemed to be the chattel of the possessor and of no other, and therefore its loss or deterioration is his loss, and to him, if he demands it, it must be recouped. His obligation to the bailor is not ad rem. And then half a dozen lines up from the foot of the page, and again, as between bailey and stranger, possession gives title. That is not a limited interest, but absolute and complete ownership, and is entitled to receive back a complete equivalent for the whole loss or deterioration of the thing itself. So that's the Winkfield. Now, certainly in subsequent cases, including cases at the highest judicial level, it's never been suggested that the Winkfield simply expresses a sui generis principle enabling the recovery of reinstatement cost and nothing else. To give an illustration of that, and I don't want to labour the point because one could give a number of illustrations, but I was going to show the court the Oakhampton, which the court will find at page 1656. It's another shipping collision case. A steam vessel was lost with her cargo after collision with the defendant vessel. I'm taking this from the head note. And amongst other things, the defendant was sued for the freight, which, but for the negligence, they would have earned if the voyage had been completed. So it's a consequential loss of income claim. This is the Court of Appeal, so I misspoke when I said it was the highest level, forgive me. But it is a court which includes the future Lord Sumner. The whole argument in the Court of Appeal just turned on was it a bailment, so there was possessory title or not. And if there was possessory title, it was seen as obvious that applying the Winkfield that the claimant could claim. And you'll see from the holding, again in the footnote, by the Court of Appeal reversing the decision of the court below, the plaintiffs had a sufficient possessory interest in ship and cargo to entitle them as bailees to maintain the action. Lord Justice Vaughan Williams, which is at page 1661.
Can you give me
1661.
16.
I got you.
Yeah.
1661.
Forgive me if I misspoke. I apologise. The second paragraph of his 1661. 1661. Sort of restoration, sort of. So the second paragraph, the Lord Justice says, the question is whether the bailee, that Robert McAndrew and co, the plaintiff, had such an interest here, such as possessory interest, so as to enable them to become plaintiffs. So that's how he states the inquiry. And then forward to the next page, the judgment of Lord Justice Hamilton, as he then was, the second paragraph of that. It now appears the plaintiff's claim is not merely for the loss of contractual advantage, which have been defeated by the collision. It's a claim for damages suffered by the loss of cargo bailed to them, in regard to which they had such rights of possession as entitled them to bring this action. So as I say, it's simply taken as read that the Winkfield principle applies to consequential losses as well as the direct insult, as it were, to the physical property itself.
I see that the future Lord Renbury agreed.
Yes, indeed. Thank you. And then, again, I don't want to labour these points, but I did promise that I would show you something at the highest level. The case that actually I had in mind at the highest level was the SS Morrison, the Morrison steamship and Greystoke Castle case, which the court will have at page 1370. Now, this is a somewhat complicated case where the House, the Appellate Committee split 3-2 on the main issue in the case. But the main issue in the case was a different issue, which is whether cargo owners had a direct right of action against owners of a colliding ship for their share of the general average expenditure. But there was a separate question on which the committee were unanimous, and on which they expressly applied the Winkfield. And that issue was whether or not the ship owners could sue as bailees of the cargo, not just for the damage to the cargo, but also for the share of the general average expenditure attributable to the cargo. And what happened is after the collision, the vessel had to put into Durban for emergency repairs. And the question was whether the ship owner, as the bailee, could recover the whole of the general average, even though some of it was attributable to the cargo interests. And all of their lordships agreed that was the position. The clearest statement is probably from Lord Porter, but I was just going to go through it in sequence really quite quickly. Page 1381 is the most mundane, because I'm simply showing that so that you'll see at 1381 that Viscount Simon, who is one of the dissentients, in the second paragraph of his speech, he records that their lordships are at one in rejecting the view of the Court of Appeal, that when the Greystoke Castle made its claim to recover general average expenditure from the Cheldale, which is partly to blame, the Greystoke Castle can only recover the net sum arrived by deducting the cargo owner's contribution. I agree with the rest of your lordships. So really, Viscount Simon just says, I'm agreeing with all of you on that point. He doesn't reason it himself. One goes forward 2 pages to 1383. This is where one does have the citation of the Winkfield in the speech of Lord Roach. And again, there aren't marginal letters, but if the court looks about 2/3 of the way down the page, and in the middle, I hope you will see the italicised the Winkfield. Yeah. That would be a good way of finding it. I cannot doubt that on the principles recognised in the Winkfield, the ship owner in a proper case can claim the whole of the port of refuge expenses on behalf of himself and the owners of cargo and freight. And obviously, having applied the Winkfield by saying on behalf of, his lordship obviously can't mean essentially by way of indemnity, because that would be the very point that the Winkfield had rejected. What he means is they can claim the lot, even though in fact the economic loss is not as between them and the bailors exclusively theirs. Then Lord Porter, which I suggested is perhaps the clearer statement. I think that's at 1403. So the first substantial paragraph, which starts on that page, beginning, there remains one further difficulty, I have said that, in my view, the injured ship might sue not only for her own direct loss, but also for any damage to the cargo of which she was bailee, and similarly might sue as bailee for the expense to which she was put in incurring general average expenditure, even though that expense was incurred in the general interest of all those concerned in the adventure. So that's Lord Porter, and then Lord Simmons, who again is dissenting on the main points, but unanimous on this point. That's page 1407. About a third of the way down the page, the court will see there's an extended quotation with inverted commas starting at each of about half a dozen lines, and then there's immediately below that, in other words. In other words, the general average contribution was the consequence and not too remote consequence of a tortious act. In the Court of Appeal, Lord Justice Scott took the same view, but supported it by an argument, which with great deference I think untenable, that only the net out-of-pocket loss, by which he means the net loss after recovering general average contribution, can be recovered by the carrying ship from the wrongdoing ship. This argument appears to me to be inconsistent with the decision in the Winkfield, which I regard as unassailable. And then lastly, at 1414, Lord Uthwat, second line, right-hand side, I have no doubt that in proceedings properly constituted, the carrying ship can, apart from the intervention made in due time by the cargo owners, on the principle laid down in the Winkfield, recover from the colliding ship the whole of the port of refuge expenses, insofar as they enter into collision damages. It's no defence to the claim that those expenses were attributable to general average acts on the part of the carrying ship and subject to a contribution. So that, again, I submit is a decision at the highest level, which is not simply confining the Winkfield to a claim for direct physical damage. My lords, my lady, I don't want to labour the point, so I don't propose to take you to it unless you direct me to. But for your note, we say that, again, at the highest level, albeit with the hat of the Privy Council, you again see the same approach in the well-known case of Candlewood and Mitsui, which is in the bundle at page 1023. Because the whole argument in that case was whether or not time charterers could recover a loss when they were not bailees. And the Privy Council holds that they can't, and it reiterates the principle in the Winkfield. But the clear premise, we say, is that if they had had possessory title, they would have been able to recover, because that is the whole nature of the debate. That would be seen at page 1037 and page 1047. But I am slightly mindful of the time and not labouring this point excessively. I should say those page numbers are bundle page numbers, not page numbers from the report.
So that's authority for, because it's a time charter, there's no possessory or proprietary.
Precisely, and time charterers are not bailees. They just have contractual rights. In fact, I don't want to over-refine it, and I can't suggest it's authoritative, but it is illustrative. If you actually look at the head, the apparatus criticus carefully, where it gives the background, you'll see that the bareboat charterer, which was a bailee, did recover its voyage expenses, and that wasn't challenged. So the whole premise of the case was that is there a right? Are you a bailee? Because if it's a bailee, it was common ground you would recover like the bareboat charterer had recovered. My lords, my lady, we then wanted to move from the rarefied world of shipping collisions to the perhaps more directly parallel world of car crashes, because there are also two decisions of the Court of Appeal which we say are, happily they won't take us very long to look at them, which we again say are quite instructive and have obviously more immediate parallels to this case. The first of those is the case of O'Sullivan and Williams, which the court will find at page 773. And it's something of a period piece, Coventry 1986, a Ford Capri. which is damaged while it's parked outside the home of the claimant's the second claimant, who's Linda McCann, who then the girlfriend of the first claimant. And she claimed damages for loss of use because although the car belonged to her boyfriend, Mr. O'Sullivan, she was its primary user, and he was actually on holiday at the relevant time. They didn't live together, it was essentially her car in terms of use, but his car in terms of ownership. And the claim, in fact, fails because the Court of Appeal found it had been compromised because Mr. O'Sullivan had accepted damages in respect of loss of use already. So that's something of a quirk. But Lord Justice Fox rehearses the principles at page 775 of the bundle, beginning at the top of the page. The qualification of a claimant in respect of loss or damage to property is stated by Lord Brandon in Lee and Sullivan. There is a long line of authority for a principle of law that in order to enable a person to claim in negligence for loss caused to him by reason of loss or damage to property, he must have had either the legal ownership of or a possessory title to the property concerned at the time when loss or damage occurred. And then there's a citation of the very well-known judgment of Lord Justice Scrutton in the Elliott Steam case, where again, Lord Justice Scrutton, you'll see it adjacent to marginal C. I'm so sorry, it cites it, doesn't quote it. And then if I can take Lord Justice Fox back up at marginal C, the second plaintiff, that's Miss McCann, the girlfriend, never had legal ownership of the car. At the time of the accident, however, she was authorised by the first plaintiff to use the car and had control of it. The first plaintiff was, I understand it, away on holiday at that time. I would assume she had possessory title at the material time. If she did have such a title, she must, I think, have been a bailee. The position of a bailee in respect of a claim for damages to the bailed property was considered by the Winkfield, and the Lord Justice quotes it. And then he extracts the principle by marginal G. So the bailee can sue a wrongdoer simply by reason of the bailee's possession. Such possession is as against the wrongdoer full and complete ownership. Now, as I say, for a specific reason, the case was dismissed. But had it not been for that, Miss McCann would have recovered what in that case would have been general damages for loss of use. But by precisely the same reasoning, if Miss McCann had herself hired a replacement car, she would have been able to recover the hire charges or as special damages. And that, we say, does begin to come very close to this claim, because, of course, this claim consists of a payment to help hire that was essentially the surrogate of hire charges. And we also say you can test it by saying, well, suppose help hire structured the bargain differently and said, well, instead of paying me my loss of income, suppose they said, Mrs. Armstead, if the car is crashed and has to be repaired, you have to pay to hire a replacement until it's fixed. Well, that, then in my submission, that would be pretty much this case, albeit it would have been a special damages, not a general damages claim. So that in my submission, though it seems the sorry tale of the Ford Capri, it is actually quite an instructive. It's quite an instructive little case, and I say little meaning it's such a short judgment, not in any pejorative sense.
But it's all over to because it was decided.
It's all over to my lord, yes. And then lastly, in the Court of Appeal authorities, this is the only case. This case again has some parallel to the instant case. It's a case called HL Motorworks and Al-Wabi, which the court will find at 1166. So this is a decision of the Court of Appeal from 1977. And what happens is it's Body Shop is the claimant. They are the bailees of a Rolls-Royce, which they are repairing for a Mr. Goldie. And at the end of the repair, they take it out for a test drive before restoring it to Mr. Goldie. And in the course of that, it gets struck by Mr. Al-Wabi. What then happens is the claim for vehicle damage is brought by Motorworks, presumably under the principle in the Winkfield, but they also do bring a claim for hire charges. But in fact, it wasn't a direct claim for hire charges. What they did is Mr. Goldie, the owner, hired another Rolls-Royce, and HL Motorworks paid him the cost. So essentially, it's a sort of self-help situation. Mr. Goldie hires a car, and Motorworks hold him harmless. And the case, it must be said, is mostly going to the Court of Appeal, firstly on the issue of liability, and secondly on the question as to whether or not replacing a Rolls-Royce with a Rolls-Royce was reasonable. So that is the focus of quite substantial chunks of the judgment. But there is also a focus on the issue as to the recovery of the hire charges by the bailee. And if I can, for that, go to page 1170 in the judgment of Lord Justice Cairns, and taking it up at marginal G in the road traffic reports.
I'm so sorry, give me the bundle page number again, would you?
My Lord, yes, 1170, and the lower half of the page, if you look for the marginal G on the right-hand side.
Yes.
Yes. So Lord Justice Cairns says, with regard to the disputed item of damages, it's essential to bear in mind this was not the plaintiff company's own car. It was a car belonging to a customer of which they were bailees. In those circumstances where a claim was made on them by the customer for the cost of hiring a substitute car, it does not seem to me that there was imposed on them a duty of querying the amount of that claim unless it was plainly an excessive one. There was no evidence to suggest, and the judge has not found, that this was an excessive charge for the hiring of the Rolls-Royce. The question therefore boils down to this: were the plaintiff company entitled to take the view it was reasonable for their customer to hire a Rolls-Royce? They were in the position that they were the bailees of their customer's car and it had been damaged while it was in their possession. On the face of it, the customer was entitled to have, during the 11 days for which he was deprived of his Rolls-Royce, another Rolls-Royce. If it could have been shown that the amount of use he wished to make of the car in those 11 days was very small, or that some other car would have been equally suited to his purpose, it may well be that the plaintiff company should not have met the full claim, or if they did, would not have been entitled to pass on the claim to the defendant. But those matters, I apprehend, would be for the defendant to establish. Moreover, unless the owner's claim was clearly exorbitant, the plaintiff company were well entitled to consider that it would be unreasonable for them to contest the claim by the owner, who was no doubt extremely annoyed at what had happened to his Rolls-Royce. And he goes on to say it might have been damaging to their goodwill. And if it was reasonable for them to meet it, it was reasonable for them to claim reimbursement. Just before I make a short comment on that, can I go on to the judgment of Lord Justice Roskill, which is at page 1172.
So is the emphasis on reasonableness all to do with mitigation?
The emphasis is really, I accept, and I think have accepted, that the thrust of the judgment really is this is being viewed as a conundrum of mitigation. Was it reasonable for them to pay for a replacement Rolls-Royce? But certainly, the parallels which I say are to this case. Clearly, it's a bailee damages a car. The owner makes a demand of the bailee to afford a replacement. The bailee does that, and the Court of Appeal's concern is not whether there is any sort of legal standing or sort of economic loss type issues around that. Its only concern is, essentially, was the owner's demand an unreasonable one? Now, of course, I accept that in this case, when we come to look at Helpar's demand, if that transpires to be an unreasonable demand, then I certainly won't be able to recover the full contractual liability. So, but I do say that though this case is a creature of the way the argument was put to, which was with a mitigation focus, I nonetheless say it is consistent with the analysis which I'm commending to this court.
There's nothing to do with pure economic loss?
Nothing to do with pure economic loss.
I mean, that would follow from the fact that it was all an argument about failure to mitigate.
Yes.
Because that only really comes into the picture if prima facie there's a liability.
Indeed, yes. It's essentially, it has been said that mitigation is a sort of is a yet further manifestation of causation, where the failure to mitigate becomes the cause of the loss rather than the initial wrong. Though I know there's quite a lot of refinement around that in the authorities. So I think just for completeness, I was going to show you Lord Justice Cairns, which is at page 1172.
Roscoe.
Oh, thank you, my Lord. Lord Justice Roscoe. It's the passage between F and J, or F and K, perhaps. So the Lord Justice says, I agree with Lord Justice Cairns entirely. And again, I accept that here too the focus is mitigation. The judge overlooked the position in which the plaintiff company were placed. They were not the owners of the Rolls-Royce, they were bailees. They had it for repair, and the plaintiff's company drivers, one of their directors, had taken it out for a trial run. No doubt the owner, Mr. Goldie, was wrathful when he found that his virtually new Rolls-Royce had been damaged in that way. As Lord Justice Cairns has said, one can hardly imagine the plaintiff company wishing to preserve the goodwill of a customer, suggesting that the owner of a damaged car, damaged while in their custody, should go out and hire a car of lesser quality than a Rolls-Royce in order to make amends for what might have been the negligence of the plaintiff's own director. And he concludes at K, yes, that can be recovered. And Lord Justice Bridge simply says that he agrees with both judgments on that point. There are some caveats in Lord Justice Briggs's judgment about the liability findings, but nothing on the question of quantum. So, my lords, my lady, with that canter through the authorities.
Your point is that unless the expense was one unreasonably incurred, the bailee is entitled to recover it.
My lord, yes.
From the wrongdoer.
Yes. And the suggestion by Royal Sun Alliance that the Winkfield principle only applies to direct claims for repair or loss of value and not consequential losses, we say is wrong. It's not supported in the authorities. Someone in possession of property is entitled to claim for losses in the same ways as an outright owner. In the words of Sir Richard Collins, the possessor is treated as the owner for all purposes. That was at page 915. And again, Sir Richard Collins, possession gives title, not a limited interest, but absolute and complete ownership.
I suppose in the HL Motorworks case, the plaintiff's inclination to pay the owner what the owner had incurred in hiring another car wasn't in fact a contractual liability.
No, and I think that is
a sort of commercial necessity.
Yes.
To maintain goodwill.
Yes. And one of the issues that I'm not proposing to take the court to it, but there is there's an interesting discussion of the case in Palmer on Belmont, and Palmer does make the point. Well, actually, one of the slightly curious things about this is the payment wasn't pursuant to obligation. No. But I don't need to get into that as a refinement.
In a sense, your case, you could say, I suppose,
is stronger.
You could say your case is a fortiori
because it is existing
contractual obligation.
Yes. And certainly insofar as Palmer, I wouldn't go so far as to say Palmer criticises this case, but Palmer sort of identifies a curiosity within it. It's not a curiosity which applies to my case, because the payment there wasn't of a donation, albeit for very good commercial reasons. It was pursuant to an obligation. And again, as I say, notwithstanding the sort of paraphernalia that gets erected on arguments as they progress up the judicial food chain, we do say that actually this case really does boil down to the simple question, because there shouldn't be any issues of duty or care. This road accident case, for heaven's sake, it should just boil down to whether or not the help hire obligation was too remote, because it is in fact unreasonable. My lords, so far as Palmer on Belmont is concerned, my learned friends do put very great store on that, and a sort of leitmotif in their written case is what they call the proprietary fiction of Belmont. But I do want to stress that we are not, or we certainly think we're not, relying on any sort of fiction. The claimant was driving a car belonging to someone else. In our submission, that is perfectly commonplace in the 21st century economy. I would ask rhetorically, what proportion of cars at this moment circling Parliament Square are owned by their drivers rather than by leasing companies, finance houses, hire purchase suppliers, or these days Uber? And the newer and more valuable the car, the more likely it is that it will actually be owned by someone other than the owner until the finance is paid off. So we are dealing with an issue which is completely commonplace and mundane. There is nothing outlandish to it. When the defendants insured negligently damaged the car, Mrs. Armstead, as its bailee, incurred a liability to its owner. Something else we submit is perfectly foreseeable. And since, as I have repeatedly conceded in this case, I don't just mean here but in the Court of Appeal, we can only get the recovery we are seeking if all the usual safeguards of the law of negligence are satisfied, scope of duty, existence of duty, foreseeability and such like. Where is the vice, I ask rhetorically, in the position which Miss Armstead is advancing?
Well, there's nothing fictitious about the fact that the driver of the car has a better title to it than the wrongdoer.
Yes, quite, with respect. So far as Palmer is concerned, I could spend a lot of time delving into it. The only reason I'm going to do that is because Lord Justice Dingemans doesn't put vast amounts of emphasis on Palmer, so I'm not going to take it too substantially. But I am just going to go to it because we actually say, with respect to my learned friends, that they somewhat misunderstand Palmer. And in fact, if you look at Professor Palmer, really the approach he's taking is the approach that we commend, which is to say the Winkfield principle is not some sort of enchantment that enables bailees to recover a greater measure of loss than they would be able to recover applying ordinary principles of negligence. But Palmer certainly doesn't argue that you can recover less as a bailee than you would be able to recover applying ordinary principles of negligence. On the contrary, his argument is that the position should be essentially should be the same. So if I can briefly look at Palmer, taking it up at page 962 of the bundle. So the heading, the limits of the bailee's recovery, where Professor Palmer says, surprisingly few modern authorities, this is 4099, advance beyond the proposition that irrespective of his personal liability or loss, the bailee can recover damages representing the market value of the chattel. It must therefore be considered whether the principle in the Winkfield limits the bailee to either of these measures or entitles him to recover additional consequential losses. So that's the point that my learned friends don't, in their written case, concede that you can claim consequential losses, despite the weight of authority which I have sought to show the court. The difficulty they have in their reliance on Palmer is Palmer too answers the question affirmatively. So at 4100, you'll see that the learned author specifically contemplates losses such as inter alia contractual liability to the bailor or another party, and various other consequential losses. And those consequential losses which Professor Palmer is contemplating, costs of hire, loss of profits, loss of use, those are all consequential losses which on the authorities we've just looked at have been recovered in the past. And then if I can go forwards over the page to 4101, the Lord, I'm sorry, not the Lord Justice, the learned author surveys the position in some Commonwealth countries. So at 4101, you'll see he cites Justice Yeldham of the New South Wales Supreme Court in a case called R.M. Campbell. And at the top of the next page, you'll see, as he says, that Justice Yeldham accepted the sufficiency of a possessory right to endow the interest holder with the benefit of a duty of care in relation to his economic losses consequent upon damage to the chattel. And he cites also the High Court of Australia in what I have to say I always think of as the Coltex oil case, but he calls it the Dredge with Armstead. And he quotes Justice where he refers to Justices Stevens and Gibson, then quotes Justice Yeldham in New South Wales. And I won't read the quotation because it's clear from the commentary that Justice Yeldham has no difficulty with consequential economic losses. And then beneath that, beneath the quotation at the foot of the page, Palmer himself says, consistently with such observations, that Bailey's possessory interest has been regarded as affording a sufficient qualification to enable him to sue for those economic losses which, while consequential on damage to or destruction to the goods, are not reflected in the pure cost of replacement or repair, and he cites the Oakhampton. And then at 4102, which is on page 965, Professor Palmer then visits Canada. where he cites a case called Tannenbaum W.J. Bell Pepperco, where Justice Gale held that the rule in the Winkfield applies against a wrongdoer who has merely damaged or depressed the value. And the judge further remarked that the result arrived at in the Oakhampton indicates that relief in actions by bailies against strangers is not solely restricted to damages for destruction of or physical deterioration to the object of the bailment itself. And he then cites other Canadian authority to like effect.
Sorry, can you just give me that reference again?
Yes, my lord. Paragraph 4102, 4-102, which is page 965 of the bundle.
I got it, yes.
Thank you.
So you say there's no problem with the bailey recovering losses, including consequential losses that the bailey have themselves suffered?
Yes.
There will be situations, but you may say it's nothing to do with this case, where the bailey does recover more than its own loss, i.e. the bailor's loss.
Yes. Well, the Winkfield would have been one of those, because obviously the postmaster didn't own any of the parcels that were lost. Yes.
But you would say that's nothing to do with this case? Nothing
to do with this case, and it doesn't prevent the recovery. It may be in to say the bailor and the bailee, obligations to account and such like, but from the perspective as to the action between claimant and wrongdoer, again, forgive me for using the hackneyed Latin phrase res inter alias acta, essentially, we say.
It's tantalising that Professor Palmer at 4100 on page 962 is really amplifying the question in that paragraph rather than giving the answer.
Yes.
And that he expressly includes in the question a contractual liability to the bailor.
Yes.
Without a helpful footnote.
I was going to say, I think it's the only one which isn't
looked at before.
The only one which isn't footnoted. Yes.
But I don't read 4100 as really answering the question, it's just fleshing out the question.
I agree with that, but the answer then lies in the survey of authority, which
yes.
I've just embarked on,
yes.
At the risk of using shipping language myself, and it acknowledges the recovery of consequential losses. I suppose it's at 4103 where Professor Palmer does say, there are limits on the principle in the Winkfield, and really these are perhaps passages which my learned friends rely on. Because at 4103, this is on page 967.
That is under the heading liability over to the bailor.
Over to the bailor. So, but as I've seen, the clause 16 here is claimed as the bailee's obligation, her contractual obligation. So I'm not relying on the bailee claiming something that she isn't liable for herself, as it were, in the shoes of the bailor. So I don't accept it's really directed to the same question. But nevertheless, my learned friends rely on this passage.
I've always found, I have to admit, Palmer on Belmont a rather intractable book, with no disrespect to Professor Palmer.
Well, my lord, obviously it would be most unseemly for me to offer to shake your hand, but I'm glad that it's not just me. But yes, I mean, it's obviously it's a towering work of scholarship, of course, but it perhaps it has points of density, shall we say. I hope from the
large book with lots of authority.
If my Lord Boris feels that I've sort of broken, sort of trespassing on academic solidarity, then I obviously apologise profusely. So what he said at 4103 is the author says, examining this question, judicial misgivings become apparent. But really, the only case he identifies is a solitary decision of the Federal Court of Australia, which my learned friends rely on, and I'll come to it if I need to in reply. This isn't an area really where there is significant disquiet, and as Palmer himself then says, claims for contractually derived losses represent one of the less contentious subjects of damage. This is because almost every modern decision from the Winkfield onwards, by accentuating the proposition that bailie's rights of recovery are not affected by the absence of liability over to the bailor, appears to take it for granted that where such liability does exist, it should represent a proper subject for recovery. And then he also makes the point, which we respectfully endorse, in footnote 443, it would seem inconsistent to allow the bailee to recover losses suffered by virtue of some contract with a fourth party, and yet to deny him those losses which derive from his contract with the bailor. We respectfully agree with that, and we also say that, again, exposes respectfully the fallacy in the approach of Lord Justice Dingemans in just saying, well, liabilities to the bailor are just something you shut your eyes to. That is unprincipled for precisely the reason that Palmer gives in the footnote. Really, my lords, my lady, what we say, what Palmer is saying, which really we say is completely consistent with our analysis, is the last paragraph I'll show you, because I don't want to take up too much time on this, and I've only got an hour left. And Mr. Smiley is no doubt chomping at the bit. 4106 at page 969, after the discussion of Miller and Candy, which is the case my learned friends rely on, Palmer says this. It's 5 lines down on the right-hand side of the page. In cases where the bailee's contractual liability to the bailor exceeds the value of the chattel or the cost of repair, there is indeed something to be said for the view that the principal in the Wingfield is expended, and the position must be judged residually according to the ordinary rules which determine liability under the particular form of action brought by the bailee against the wrongdoer. The same may also be true of such contractual liabilities as are owed by the bailee to some fourth party. It would seem to follow that such losses are, it would not follow that such losses are necessarily irrecoverable, but merely that the special rule in the Wingfield cannot be invoked as automatically justifying their recovery, for it can hardly be supposed that the decision entitles the court to disregard the normal limitations of foresight, causation and remoteness. And then in the next sentence, alternatively, it may be proper to conclude that any extension of the rule in the Wingfield to what may broadly be termed non-physical categories of damage, or to categories of loss which do not arise directly from physical damage to the chattel, should be subject to the conventional principles which govern the recovery of damages under the particular form of action in question. Well, my lords, my lady, we say that that is our analysis. Yes, there is no magic in the principle of the Wingfield, apart from the fact it treats me as the owner of the property. It gives me locus standi to bring the claim. After that, the Wingfield is discharged, and you apply the principles which are the conventional principles, quoting Palmer, you apply the conventional principles governing the recovery of damages under the particular form of action in question, viz., in this case, negligence. And so I've taken an hour, half my time addressing you on principles of bailment, whereas, as I made clear at the outset, we actually say that save as the initial, if I can sort of put it colloquially, sort of mounting block that facilitates me as the non-proprietor of the car bringing this claim is actually irrelevant, and what this claim actually has to be tested against is ordinary principles of negligence, to which I will, if I may, now turn. So this is the third. My third theme. In our submission, since the claim is consequent on damage to what the law regards as Mrs. Armstead's property, my learned friends say it's a claim for pure economic loss or relational economic loss. Well, we say, well, no, it isn't. It's damage which is consequential on damage to the car. And it's a very simple proposition, and though it's very important to my case, I'm not going to elaborate it any more than that. So the question in our submission is whether the Clause 16 liability is such a loss, and if so, whether it's recoverable, applying ordinary considerations such as foreseeability and remoteness. Now, as a starting point in this part of our submissions, we say that although Lord Justice Singh in particular appears to disagree with us, as a starting point, the Clause 16 liability is clearly a consequential loss resulting from the accident. Now, Lord Justice Singh says, well, it results from the contract. But with respect to him, of course, in one sense, that's right. But it simply isn't an answer. Many consequential losses involve contractual liabilities incurred or contractual gains foregone to third parties. And the law specifically recognises that where foreseeable contractual liabilities triggered by torts, they can found recoverable losses. And in this part of my submissions, I'm going to refer principally, as my sort of lodestar, to the decision of the Court of Appeal in the Network Rail case, which the court will find begins at page 730. Was the Network Rail case? Network Rail was a case concerning the liability of motorists who had caused accidents such as bridge strikes. I see some. If some of your lordships have the hard copy bundle, it's tab 10, page 310 of the hard copy. It was a case concerning liabilities of motorists who've caused accidents such as bridge strikes which had damaged the railway. That causes direct physical damage to the infrastructure which is owned by Network Rail. It also causes loss of revenue to train operating companies using the railways. But since their property isn't damaged, those are pure economic losses. They can't claim for them. But the issue in this case was that those companies under their contracts with National Rail were entitled to compensation subject to some pretty complex calculations under what for shorthand was called Schedule 8. So in the report, the court will see it's called the Schedule 8 liabilities. And so the question in the case was, could National Rail include in its Schedule 8 liabilities, could it include its Schedule 8 liabilities in its claim against the negligent motorists? And Mr. Justice Aikenhead and the Court of Appeal held that they could. And really what I deploy this case to show is on my first premise that in fact this isn't really about Belmont at all, apart from Belmont giving me the standing to bring the case in the first place. This conundrum, can I claim for a contractual liability under a pre-existing contract which has been triggered by the wrong done to my property, is indeed answered by applying ordinary principles of negligence. The sort of argument which the Court of Appeal accepted in this case, that somehow the contract was a separate cause, was rejected. And the only question which they asked was it too remote? And they held that it wasn't, because in that case they found the Schedule 8 liabilities were reasonable. And in fact, that was ultimately conceded. I think quite a lot of effort in the High Court have gone into exploring Schedule 8, but by the time we get to the Court of Appeal, your Lord Briggs looks astonished.
Well, just a recollection of having had to try and explore it in the past. It's quite a task.
Yes, I can well imagine. And some of the arguments in this case are not dissimilar to those which my learned friends deploy. And so if perhaps I could show you, for example, at page 756 of the bundle, that's paragraph 94 of the decision. Paragraph 94, I think this is Lord Justice Morbick, is summarising the arguments of Mr. Bartlett for the motorists. And one of those arguments, I'm going to go down to marginal D. Just below marginal D, there's a sentence that begins, the real cause of the liability. The real cause of the liability to make Schedule 8 payments were the terms of the track access agreements. The liability to make payments of that kind was not reasonably foreseeable by those using the roads, and therefore fell outside the scope of their duty of care or was too remote to be recoverable, or it wouldn't be fair and reasonable to hold the motorist liable for very substantial losses of that kind. So again, the argument that somehow the agreement rather than the tort is the cause of the liability is similar to what's being argued here as the points about remoteness. And then at 97, which is on the next page, continuing to summarise Mr. Bartlett's case, between marginal B and C, the sentence beginning, in effect, he, that's Mr. Bartlett, sought to treat the losses in respect of which the train operating companies were entitled to be compensated as if they were Network Rail's own losses. Indeed, one of his submissions was that Network Rail would not be entitled to recover in respect of a future loss of business if it was operating rail services for its own account, especially if that were based on a rather speculative assessment of a reduction in public confidence in the reliability of the railways. I interpose to say that was one of the criteria that was taken into account in calculating the Schedule 8 payments. It should therefore not be better placed simply because it's providing the infrastructure which enables the TOCs to do so. He also relied on the fact that since it was common ground the TOCs themselves could not have recovered damage in respect of pure economic loss of that kind, it would not be right to enable Network Rail to recover such loss simply by entering into contracts with the TOCs to indemnify them. So again, arguments that have got some resonance with the sorts of points which are made against me. My Lords, the points about causation, firstly, was decisively rejected, and is perhaps put most clearly, if I can respectfully say so, by Lord Justice Pill at page 740, paragraph 32.
Just give me the page number again, please.
My Lord, it's bundle 740, internal page 702 of the report.
I see.
Paragraph 32. So Lord Justice Pill says the incidents of which the appellants were responsible, that's the bridge strikes and such like, undoubtedly triggered the payments the respondents were required to make to train operating companies under contracts with them. The payments were the direct consequence of the incidents. The contractual loss by the respondents is a direct consequence of the injury to the tracks. And obviously I say with necessary modifications precisely the same. The clause 16 liability is because the hire car was damaged and ceased to be available for the owner to rent out to other customers. So what I might call Lord Justice Singh's causation point really has no traction, and with respect we say that's right. So far as the issues of duty and remoteness are concerned, all three of the judges expressed themselves slightly differently, although they all come to the same conclusion. I was going to, if I might begin with Lord Justice Jackson, at page 771, 771 of the bundle. Paragraph 145. The common law rules and principles which regulate the recoverability and assessment of damages form a vast and rippling skein. I have to say, I've been trying to work out whether he's meaning skein in the sense of yarn or skein in the sense of geese, and I'm not quite sure. But perhaps I will ask him at Chambers Tea. The common law rules and principles...
The judges and the jurists to the...
the common law... the vast and rippling skein. I would not presume to offer a comprehensive review of that skein. I do, however, suggest that the four principles relevant to the present appeal can be discerned from the authorities. One, economic loss which flows directly and foreseeably from physical damage to property may be recoverable. The threshold of foreseeability does not require the tortfeasor to have any detailed knowledge of the claimant's business affairs or financial circumstances, so long as the general nature of the loss is foreseeable. Two, one of the recognised categories of recoverable economic loss is loss of income following damage to revenue-generating property. It's the first 2 points really I rely on. Three, loss of future business as a result of damage to property is ahead of damage on the outer fringe of recoverability. Whether the claimant can recover for such economic loss depends on the circumstances of the case and the relationship between the parties. In choosing the appropriate measure of damages for the purposes of assessing reasonable economic loss, the court seeks to arrive at an assessment which is fair and reasonable as between the claimant and the defendant. So those are the principles which he states, and then his treatment of them can be found at the foot of the same page, paragraph 148. The railway lines owned by Network Rail are revenue-generating assets, and he says the division between Network Rail and TOCs is a matter of public knowledge. 149, it's plainly foreseeable that if railway lines are damaged, Network Rail will suffer a loss of revenue. I make the same point about damage to a vehicle. 150, in my view, this action should be characterised as a simple claim for loss of income consequent upon damage to revenue-earning property. This is a well-established category of recoverable economic loss. Network Rail's loss is the direct consequence of physical damage and is a type of loss which is readily foreseeable. Obviously, a negligent driver approaching a railway bridge or level crossing, or the employer of such a driver, will know nothing of the detailed arrangements existing between Network Rail and the TOCs, nor does he need to possess such knowledge in order to be fixed with liability for Network Rail's loss of revenue, while the rail track is unusable as a result of negligent driving. The present litigation has involved a minute scrutiny of the formulae and calculations which are used to assess compensation for TOCs in respect of periods when railway lines are unavailable. There is nothing unusual or untoward in any of these formulae or calculations. It's hardly surprising they are complex. Absent some exceptional circumstance or obviously unreasonable feature in the claimant's business arrangements, in my view, it is not appropriate for the court to explore in detail the build-up of any loss of revenue following damage to revenue-generating property. It's sufficient for the claimant to prove that the loss of revenue has occurred. The law of tort should, so far as possible, be clear and simple, obviously a slightly hollow laugh. This court should not superimpose as a requirement for expensive legal inquiry upon categories of case where there is an established entitlement to recover economic loss. The exploration of the build-up of Network Rail's revenue loss in the present case has not revealed any exceptional circumstance or unreasonable feature of Network Rail's business arrangements, and so the Lord Justice holds it can be recovered.
Although he describes it as loss of income, I mean, it's an expense that they're paying out to the operating companies, isn't it? Which obviously results in them getting less income than they otherwise would. But
you're quite right.
The analogy here is with an expenditure,
my Lord,
incurring a liability to the third party.
My Lord, absolutely. That's quite right, if I may say so. Obviously, I'm sorry, my Lord.
One question. You would say, I think, that the economic loss here is directly consequent on damage to the car. Is that actually a necessary requirement on your case? Or is it sufficient that it's consequent?
I would say it's sufficient that it's consequent, but I do, your Lordship is quite right to surmise that I do say it is simply a direct loss if you damage someone's car and it's taken off the road.
Just that sometimes the definition of what is pure economic loss is put, as I understand it, in one of two ways. One is it's directly consequent on damage to one's property, or it's consequent on damage to one's property. But you say it makes no difference for the purpose of this case.
That's my submission, yes.
Thank you very much.
Before moving to Lord Justice Moore-Bick, because just to anticipate the submissions I'm going to make as to why we say that Clause 16 here is reasonable.
Just before you do, just following up on my Lord's question, I suppose if it's directly consequential, you're unlikely to get into the sort of thickets of remoteness and foreseeability to quite the same extent as you would do if it was only indirectly consequential. If it's indirectly consequential, the sort of paper trail you have to go through has in principle to be foreseeable, doesn't it?
Yeah. Yes, I certainly wouldn't dissent from that. And clearly what I say, as you know, my proposition, and I appreciate I've articulated already, is this really is a very simple case with only at the end a question which merits perhaps close attention, which is, was Clause 16 itself reasonable? Because if it wasn't, certainly the full extent of the loss thereunder won't be foreseeable. But in terms of getting up to that, I do, in terms of negligence, I do say this really is extremely simple. It's a road traffic accident. You've damaged someone's car. Perfectly foreseeable that the direct consequence of that would be an economic loss. I mean, you know, it might have been Mrs. Armstead was using it to, she lived in a rural area, she had to take a week off work, it might have been a loss of earnings. She may have gone out and had to hire a replacement, all sorts of things. Perfectly foreseeable. And with great respect, we do say this is a case not just by the parties, but by with very great respect by the Court of Appeal has been needlessly overcomplicated. What really everybody should have jumped to was straight, let's look at Clause 16. Is that loss foreseeable? Because that's what we say it really turns on. Obviously, in the run-up to that point, which I'll come to very shortly, I obviously seek to draw some support from Lord Justice Jackson deprecating a minute scrutiny of the relevant contract and really asking oneself simply, is it obviously unreasonable? And we say that approach doesn't differ in principle from that of Lord Justice Moore-Bick. And if I can take that up at page 757, paragraph 98. So he begins 98 by obviously referencing something which isn't common ground in our case. I think it worth reminding myself that it's been accepted by all concerned that Schedule 8 payments do represent the best assessment in financial terms. So that obviously is a difference.
Give me the page number, sorry.
Forgive me, my lord, it's page 757 of the bundle.
757.
This,
Thank you.
isn't this the passage that earlier you said was Lord Justice Pill?
Oh, I thought I said it was Lord Justice Moore-Bick, but if I didn't, I apologise. It is Lord Justice Moore-Bick.
Yes,
I'm
yes.
grateful, my lady. I think the passage I said was Lord Justice... What I intended to say was Lord Justice Pill was the passage at paragraph 32 about...
It may be my mismemory.
Well, not at all. Unfortunately, my laptop screen is sufficiently small that I can't sort of view the whole page at once, so I do apologise if I misattributed.
Can I just, at this point, come back to the point that Lord Leggett made a moment ago, that what is said here is that it's the best estimate in financial terms of the commercial damage caused to the TOCs. Yes. But it's otherwise put, as we saw in the earlier, or the other passage you took us to, as a loss of revenue suffered by Network Rail, and I'm rather puzzled about this as well.
I wouldn't dispute that it is a slightly curious way in which Lord Justice Jackson expressed it, because clearly what it unquestionably is, it's a contractual liability in Network Rail to hold the TOCs harmless against their loss of revenue under what I'll employ the shorthand of the Schedule 8 liability. So certainly,
I assume what he meant is that they have to make payments to Network Rail for the track, and there are deductions from those. Well, and this is such a deduction, so that Network Rail gets less income.
Well, I think that is what's meant, and in fact, I think probably the payment did take place by way of set-off against the...
I'm sure it did, but it was, I mean, one can see from the description of how it was calculated that it is actually an attempt to assess the damage, the loss suffered by the TOCs.
It certainly is, yes. And it was an aspect of the case that was important was that it was felt to be a fair pre-estimate of that.
Of their loss.
Of their loss. And of course, what's said against me by my learned friends is that Clause 16 is not a fair pre-estimate. And as I've repeatedly said, in my submission, that's actually the real point in the case. I'll come to it once I finish with Network Rail. So I was in paragraph 98 of Lord Justice Moore-Bick. So what his lordship says by marginal G, he's talking about the Schedule 8 requirements, and he says, as the judge observed, on the right-hand side of the page, they are similar to liquidated damages provisions of the kinds that are commonly found in commercial contracts relating to areas of activity where the effects of delay or interruption of performance are difficult to quantify. That's important because it means the extent of Network Rail's liability to the TOCs, and therefore this head of loss cannot be regarded as too remote on the ground that it exceeds any reasonable assessment of the amount of loss actually caused by the loss of availability of the track. So again, he puts emphasis on Schedule 8 here, not exceeding any reasonable pre-assessment. And then essentially, and then you get that again at 99. In my view, it's wrong to approach the question that arises in this case through an analysis of the Schedule 8 payments as if the claims were the TOCs. All that matters for present purposes is that they represent a genuine and reasonable attempt to assess the damage caused to the TOCs by the closure of the lines. So at the end of this paragraph over the page, he says, in my view, the judge was right, therefore, to approach the case by asking himself whether a loss in the form of the liability to make Schedule 8 payments to the TOCs under the track access agreements was within the scope of the appellant's duty and not too remote in law to be recoverable. And then at 101, same page, he says, it's clear, therefore, that two types of loss flow naturally from any damage to the infrastructure, the cost of repair and the loss of revenue. Both are, in my view, within the scope of the duty of the motorist, or indeed anyone else, to exercise reasonable care not to cause physical damage to the infrastructure, subject to the limitations imposed by the rules relating to remoteness. Therefore, all such loss is in principle recoverable from the party who caused the damage. And again, this in my submission is consistent with the analysis which I am commending. You test this case by asking, is the Clause 16 liability one which can be recovered applying these ordinary principles of negligence? And then still in this paragraph below marginal H, his lordship says the fact that in the present case the loss took the form of a liability to make payments under the track access agreements does not render it irrecoverable, since liability depends only on foreseeability of the kind of loss suffered rather than the manner in which it was caused. And that obviously is an echo of the famous Hughes and Lord Advocate principle. And then he cites a case which we cite in more detail in our case. I'm not going to turn it up now because of time, but it is also, if I can respectfully say so, well summarised in Network Rail. That's the case of Emler Hall, a decision of the Court of Appeal. Another car crash case. That's where a car crashes into a showroom belonging to a plaintiff lessor, but let to a third party. And as Lord Justice Morbick says, the showroom became unusable for several weeks, during which the tenant ceased to be liable for rent under provision of the lease. The court held that the plaintiff was entitled to recover damages for the amount of the lost rents as financial loss flowing from the physical damage to the building. It did not matter that the defendant might not have foreseen that the lease would contain a clause of that nature, provided that he could foresee financial loss of some kind. There is no material distinction between that case and the present, the loss of revenue taking the form of loss of rent rather than the payment of a sum in compensation for the unavailability of the property. So I suppose there he is also saying it's a loss of revenue, albeit it actually takes the form of a payment of a sum in compensation. Applying established principles that govern causation and remoteness of damage and tort, it's difficult to see why the loss of revenue represented by the Schedule 8 payments should not be recoverable. My lords, my lady, for your note, the Elmer case will be found at page 592 of the authority bundle. And it's addressed also at paragraph 16 of our written case. I come lastly to back to Lord Justice Pill, because Lord Justice Pill, I think to some extent my learned friends rely upon his treatment of the Schedule 8 liabilities, and so that's back to page 751. Lord Justice Pill agrees that the loss is recoverable. So on 751, paragraph 81, I have come to the conclusion the appellant should be liable for each of the heads claimed. 82, it was reasonably foreseeable that if the respondent's apparatus was damaged, the services of the TOCs and their value to the public would be diminished, and that arrangements would have been put in place by the franchising authority to penalise the TOCs for the diminution in their services. And obviously the TOCs get penalised, so that's part of the Schedule 8 calculation. Two contracts are involved. The contract between the respondents and the TOC, and the franchising arrangement between the franchising authority and the TOC, but the complexity does not render the resulting loss to the respondents too remote from the physical damage. And then at 83, and I think this is a passage my learned friends focus on when they come to their critique of my Clause 16, and it's the penultimate sentence of the paragraph. Provided a genuine attempt has been made to assess future loss of income from this cause, and on the evidence I am satisfied it has, a bar is not placed on recovery by reliance on passenger psychology. So the Lord, and it perhaps is also right, just while I'm here, that I do show you that certainly Lord Justice Pill did say that the terms of the contract couldn't be conclusive, and of course I don't suggest it's conclusive because I accept I have to meet I have to meet the critique of Clause 16, and perhaps just to make that good, I'll show you page 749. And then I'm out of this case, you'll be delighted to hear. Page 749, paragraph 68, where the Lord Justice says, the losses claimed satisfy the requirement of being a direct consequence of the tort. The liability of the respondents to pay sums to the TOCs is the direct consequence of the tort which occasioned the damage to the tracks. However, it also has to be considered whether the appellants are bound by the assessment of damages in the contracts between the respondents and the TOCs, and if not, whether that damages claimed are reasonably foreseeable, see the wagon mound. Attractive as is the simplicity of a solution by which the tortfeasor is liable to pay whatever the respondents and the TOCs agree as between them, such an agreement does not, in my judgment, necessarily bind the appellants as tortfeasors to pay the agreed sum. And as I say, my lords, I take no issue with that. I do not say that Clause 16 binds RSA, because if it is, in the words of Lord Justice Jackson, obviously unreasonable, then it won't be foreseeable. But in my...
I'm going to come to that, but is that right? I mean, people foresee that people enter into unreasonable contracts. Surely it's reasonably foreseeable that someone might enter into a bad bargain.
Yes, well, I mean, obviously that was a point which we reflected on. Praying in aid as we do the Network Rail case. The Network Rail case certainly contemplates that there may be bargains which are too remote in their improvidence. But I certainly would say that that's not necessarily something to be determined on a completely level playing field where you would second guess the contracting parties. And to that extent, it is telling, in my respectful submission, that Lord Justice Jackson uses the terms of obviously unreasonable, and Lord Justice Pill, paragraph 79, he thinks it's reasonable because the agreement is drafted responsibly and with a view to a fair result.
Trying to get to the principle.
Yes.
If one says we're on remoteness because we're talking about foreseeability, I'm just teasing out why reasonableness is coming into this, in the sense that it's perfectly foreseeable that people will have entered into bargains that might be regarded as unreasonable. So is it a question of remoteness, or is it some other principle?
Well, of course, one of the principles which the court in Network Rail sets its face against is a more sort of a general principle of fairness and reasonableness as between wrongdoer and victim. I mean, I, for my part, would place it as part of a remoteness analysis, which is how the Court of Appeal analysed it by saying that obviously, in one sense, in one sense, it is foreseeable, I suppose, that people will engage in improvident bargains, but on the assumption that people in a 21st century economy transact rationally, the starting point would usually be that if somebody actually does enter into a bargain which really is wholly improvident, completely divorced. And for example, let's imagine it actually was a penalty, as between.
If it was a penalty, it wouldn't be a contractual liability.
It wouldn't be a contractual liability, would it?
And so indeed, that's what was pleaded against you at first.
It was.
And that you'd failed to mitigate by not simply saying I'm not bound by the contract.
Indeed, that wasn't a point that was ultimately maintained.
Short of that, which isn't something which I think can be pursued before this court, it fell by the wayside on the way up.
At least something did.
But why is the fact that it was simply that it's a binding contractual liability, albeit a tough one, take it outside foreseeability? Well, is that a remoteness problem?
I mean, it may be that I'm not putting my case with sufficient energy. The way I've put it is that an improvident a wholly unreasonable bargain or wholly improvident bargain would be I've essentially have accepted that would be not foreseeable. But it may be.
Well, ultimately, these principles are about saying that there comes a time when consequences should not be, the defendant should not be made liable for them, because they're not the sort of things that he could expect to be liable for as a result of what he's done. And if the bargain is too unreasonable, then one may say that line has been crossed. That's what underlies it.
We all know there are extreme cases like the Ruxley Electronics case about the swimming pool, for example, where the I don't really want to get into that because it's such a notoriously difficult case, but there obviously are points at which.
You could say, as a matter of causation, that part of the loss is attributable to to the claimant's irrational conduct.
Indeed. There are all sorts of, as so often I think it may be in this area, there are actually a number of labels which you could possibly apply to justify a particular outcome. In this case, I'm suggesting whichever of the labels you apply, you simply cannot say that the short, time-limited clause 16, which simply says that the claimant will pay the same price she's already agreed to pay, it just can't. Whatever label you attach that sort of reserve of improvident bargains, this bargain is not that bargain. And perhaps that's the point at which I should come to what I've been saying throughout is the real issue in the case, which is clause 16, unless there's any, if Lord Burrows is content that I'm grateful. So the reasonableness of clause 16, to some extent I preempted what I was going to say with that short debate. We do say it's not enough, as it were, to cart from the sidelines to say, well, clause 16 could have been less onerous. And the principle which is being applied in the case is essentially the Hughes and Lord Advocate principle. A loss is not unreasonable so long as it's of a type which can be reasonably foreseen, even if it happens to be within that type a rather radical loss. But we don't even accept that about clause 16 in our respectful submission. It is perfectly reasonable. Can I start this part of my submissions by addressing very shortly what we say is an obvious canard? A point my learned friends repeatedly make in their written case and in the lower courts is that if Hellpower brought this case, it would have been confined to a claim for interest and depreciation on the capital value of its asset. You have that, for example, in paragraphs 8 and 11 of my learned friend's written case. But we say with respect to them that is obviously wrong, because this was a revenue-generating asset. And the cases they cite are cases explicitly about non-revenue-generating assets. So if I am driven to say that in this part of their argument, my learned friends are simply taking a wrong-headed starting point. It's obvious that if Hellpower brought a claim, it would have brought a claim for loss of profits.
Said it would have hired the car to somebody else if it hadn't had to...
Quite, and which is obviously the very thing to which clause 16 is directed. Again, although this point was made with equal persistence below, it was rejected by Lord Justice Dingemans, who, though against me on absolutely everything else, does say at paragraph 61, I don't ask you to turn it up, but at paragraph 61 he said the claim should have been formulated as a claim for Hellpower's lost income. He just considered that clause 16 didn't crystallise it in a reasonable way. So even Lord Justice Dingemans doesn't support this point about interest and depreciation costs. I'm not going to invite you to turn them up, but the two cases my learned friends cite, the first is Beechwood, Birmingham and Hoyer Group, which is at page 424 for the court's note. As the head note shows, will show, that is a claim for the loss of use of a car which was used by an employee and was one of a pool of cars kept for employee use. And the whole premise of the discussion in Beechwood is that it was not a revenue-generating asset. And if in due course, your Lordship, your Ladyship, turn it up, you will see that the President, Sir Mark Potter, meticulously analyses some very famous cases about which I know some of which are critiqued by my Lord Burrows in his book on remedies, as Sir Mark Potter records, about the measure of loss for non-revenue-generating assets, like the lightship in the Mediana, or the Greta home in the Hebridean coast. Very famous Admiralty cases about non-revenue-generating ships. And the other case my learned friends cite is West Midlands Travel and Aviva, which is at page 923, a decision of the Court of Appeal. That again is a decision about a non-revenue-generating asset. It was a bus company which kept a stock of reserve buses which they could substitute for buses which were off the road with mechanical failures or accident damage. And what they were claiming was the cost of maintaining their substitute fleet. There was no claim for loss of profits in that case either. So we do say those are not in point, and that is reinforced by the suggestion I've made already, that Clause 16 could perfectly reasonably have operated by requiring Mrs. Armstead to arrange and hire a replacement. So nothing outlandish in saying, Mrs. Armstead, on this strict liability that you've agreed to, where irrespective of fault, you will hold us harmless from damage to our property and loss of revenue, for that to be quantified with reference to a higher charge in my
What was the page number of that second case?
The second case, my lord, was page 923.
Thank you.
So, so far as the reasonableness of Clause 16 is concerned, I've already shown you it's a clause which is replicated in other hire contracts. Its reasonableness in my submission has to be considered against the context that these are simple consumer contracts where for low-value transactions, where transparency, certainty and simplicity are important. As is the avoidance of dispute and the need for an exercise, for example, if Helper did bring a loss of profits claim against Mrs. Armstead, for example, and that is something over 30 days of hire. So it's never going to be a case which involves damages above what in the county court would be small claims tract cases. A loss of profits claim that would require an exercise in disclosure and calculation out of all proportion to a potentially small liability. And of course, you saw that in the Network Rail case, Lord Justice Moore-Bick drew a comparison with liquidated damages clauses. Obviously, I'm not suggesting that a liquidated damages clause in a complex construction contract can be equated to Clause 16. But the sort of thing at which Clause 16 is dedicated to achieve, in my submission, is nonetheless precisely the sort of thing a liquidated damages clause is dedicated to achieve: the avoidance of dispute, the introduction of simplicity, the obviation of the need for case-specific calculation with disproportionate disclosure and such like.
Does the expensive insurance that car hire companies offer their customers include offer of insurance this liability or not?
I'm sure that it does, yes.
No.
Yes, I mean, obviously, and in fact, in this case, it's not an issue that's been explored. The claimant did have some kind of collision damage waiver, but presumably, even if, in fact, the insurer is not is liable for the Clause 16 liability, that would be raised inter alia acta.
Absolutely would. I'm just interested in you're talking about the commercial operation of it, so I'm just seeing how it works.
I think one can say with some confidence that whether it be an accident hire company like Help Hire, or or Auxilis, as it's now known, or a mainstream car hire company like Avis or Hertz. The purpose of these clauses probably is not any expectation that their clients will have to defray from their own pocket these expenses. They will defray from the proceeds of insurance, and obviously in a non-fault case there will be an attempt at some kind of subrogated recovery, no doubt.
Can you just remind me, there's no issue now before us as to whether this clause is contractually binding. That's right.
There is no issue as to that. No. I think that's right.
Yes. Okay. And there was an issue previously as regards liquidated damages or penalties, but that point was never pursued.
Forgive me, my lord, I didn't quite catch the last bit of what you said.
Sorry, liquidated damages or penalty clause.
There was an issue about penalties that was pleaded. It wasn't, the district judge didn't make a finding on it, and it was never renewed.
Well, it is attempted to be renewed, as I read the respondent's case now.
Well, yes, and you'll see, again, I appreciate that at this level in particular, I don't want to get into procedural sniping, but we do address history in quite a lot of detail in our written case. And just because I don't take up the court's precious and limited time on it orally, I certainly don't abandon those complaints in any sense, but I just rely on my case in those respects. Just finishing the points about Clause 16, the liability is limited to 30 days, irrespective of the actual length of repair or lead time for repair. Now, my learned friends say, well, there's no evidence about this, but we say it's obvious that some cases may last longer than 30 days. This is an unusual case because Mrs. Armstead appears to have been happy to go on driving this quite seriously damaged car for 12 days, or however long it was, before it went in for repair. But obviously, if a customer said to a hire company, well, I don't want to go on driving this damaged car, that's something an awful lot of claimants would say. So in an awful lot of cases, the moment the car is damaged, even if it's weeks before you can get the parts, the car is off the road. And certainly you're not going to hire it, you're not going to hire it to somebody other than Mrs. Armstead in a smashed up state. So we do say the fact that liability is limited to 30 days is an important point, which and as we say in our case, there's a swings and roundabouts element here. It's just about trying to give, about apportioning the risk in a way that, yes, in certain circumstances may favour one side of the bargain, but in other circumstances might favour the other side of the bargain. Because it might be that the car is really quite seriously damaged and you're 30 days just waiting for parts. And then it's another 2, 3 weeks, 4 weeks, however long before the car can be repaired. So it's obviously a one-size-fits-all mechanism, but that's in the nature of this sort of clause in our submission. And obviously also, again, Mrs. Armstead is unusual because here the car is, because she's happy to go around driving it in its damaged state, the car is repaired after the hire comes to an end. But of course, in many cases, at the point the car is damaged, it comes off the road immediately. What ex hypothesi, therefore, it's been damaged while it's out on hire, and so it comes off the road. There's an instant loss of income, and again, that shows in our submission by limiting it to 30 days is reasonable. The clause 16 price is the daily rental charge, i.e., the very rate the customer has already agreed to pay. My learned friends made the point quite reasonably that that is not a price that will always be recovered under Help Our's business model, which is the accident hire business model of claiming it back from the negligent third party. And they are right about that. But two points in response to it, or 3 points in fact. Firstly, we say that's all part of the swings and roundabouts and the 30 days, for example. Secondly, it doesn't follow from that it's unreasonable as between the customer and Help Hire. The reason the customer can't always recover the full cost from the wrongdoer is because the House of Lords held that the wrongdoer isn't liable, for example, for the credit element in ordinary circumstances. But Mrs. Armstead herself, she's had the credit element. So it's perfectly reasonable to charge her more than Avis would charge her, even though it's not something recoverable between the parties. But also, and of course, this we say in these cases it is important. In many cases, the full hire cost is recovered between the parties because the House of Lords went on to distinguish Diamond and Lovell when it overruled the Lees-Bosch or departed from the Lees-Bosch dredger in the Langton and O'Connor case, and says that in cases where claimants can't, without financial embarrassment, pay hire charges up front, they can recover the full credit hire cost. And that's not a narrow exception. I mean, obviously, we're in the week of the autumn statement and a great deal of press coverage about the cost of living crisis. I'm not going to get into that, but the proportion of fellow citizens who, if completely out of the blue their car is damaged, who can actually just put down a credit card and pay £1,000 to Avis or Hertz, that's a pretty small proportion of the population. We would venture. So Langdon is not one of those rare exceptions. It is, in fact, an exception which is perhaps at least as large as the rule. So there will be many cases where the full cost would be recoverable. My learned friends, as has been said, have referred to penalties, although it's not a point maintained on appeal. But if one was to apply the language of penalties to Clause 16, could it be described as extravagant or unconscionable in comparison with the greatest loss that could conceivably be proved? Well-known statement of Lord Dunedin in the Dunlop tyre case. Or in the modern language of parking I, could Clause 16 be said to impose a detriment out of all proportion to any legitimate interest of helper in enforcing the primary obligation? And we say not. We say it can't be seen in the language of Network Rail as a non-genuine or obviously unreasonable clause. Yes, it may lead to a liability different from that which Help Hire would have claimed itself. But that's in the nature, for example, of a liquidated damages clause. I mean, the whole point is that you don't have a nuanced and fact-specific quantification, but it doesn't therefore follow that the point is unreasonable. And as we've seen in Network Rail itself, the clauses the court was concerned about led to liabilities which were radically different than either Network Rail would have been able to claim for itself, And in that case, of course, the TOCs had no claim themselves at all, because theirs would have been a claim for relational economic loss. But the fact that the clause thereby enlarged the wrongdoer's liability didn't defeat the claim, the clause not being unreasonable. And we say that the same point is here. My Lords, I said also that we do have procedural complaints about the renewal of issues about penalties and such like. So far as that's concerned, again, for your Lordship's note, it's in our case, which is at paragraphs 33, sorry, pages 33 to 35 of the key documents.
What's the bundle pagination? The
bundle pagination, sorry, let me slip back, pages 80 to 82.
80?
80 to 82, my Lord.
Sorry, there was one sentence that you used that I didn't quite pick up and I may have misunderstood. Clause 16, how is that price worked out? Is it the same? Did you say it's the same price?
It's the tariff that she agrees to pay per diem.
Yeah.
Yes.
So if instead she'd hired another car during the period of repairs, that would be in the price she would have been charged.
Well, of course, that takes us back to the point about that depends whether she goes to a conventional hire company, and that's the last point I'm coming to before I give way to Mr.
All right,
Simon.
it might be a different charge from them.
Yeah, the evidence which they put in front of the district judge, and which never surfaced again until a couple of weeks ago, does suggest that a conventional hire company might have charged about half as much.
Right.
Half, did you say?
In very rough terms. What I might do, because I am conscious that I don't want to deprive Mr. Smiley of his moment of glory, and I've got 15 minutes left, so I deal with the basic hire evidence quite shortly. But perhaps I think if I can give Mr. Smiley 10 minutes, so I can take 5 on the agreed timetable. So just to show you the basic hire evidence that's been added, that's at page 224 of the bundle.
224?
224, my Lord. And 225. There are really 3 tables. At the top of page 224, there's a table of what 3 other hire companies would have charged for a BMW 1 Series or similar. I don't think we've actually got any evidence about whether a BMW 1 Series is a reasonable surrogate for a 2-litre Mini. That's just not, because this wasn't explored below, we don't have any factual findings. But what they do show is that a BMW 1 Series would have cost table 1 somewhere between £400 and £500 for 12 days. But then you have to add the insurance charges, which is table 2. And that adds another sort of 200 to 336 odd. And that then leads to table 3, which is on page 225, where you see it said that with a non-accident hire company without the credit and such like, the transaction would have been between about £674 and £792. And then there's no doubt very useful for exposition to the learned district judges in a busy list. There's a bar chart which shows that Helpar is a sort of outlier. Obviously, that's because you're comparing apples and oranges, we would say. My lords, my lady, this is what we've put in our note about, and we do say that this is not evidence that's been subject to any factual findings. It was in the bundle, we think, before the Deputy District Judge. It's not referred to in his judgment. It was not referred to either of the junior appellate courts. None of the judges below rely on it. It's not the way the case was ever pleaded or anything of that sort. And for that reason, Helpar Auxiliis through Mrs. Armstead have never responded to this evidence. And we say it is unfair to reintroduce it at this stage. For example, those figures, they don't tell us, for example, the proportion of Helpar cases where you would recover the Helpar cost because of the Langton and O'Connor exception, which, as I've already surmised, may be very high. Nor do they address questions like whether or not a BMW 1 Series is in fact the equivalent of a Mini with a 2-litre engine. Can I just say, however, that if we're wrong about absolutely everything that has come to pass, I would seize on this clause, on this new evidence which they have put in, to say, well, if your lordships do find the clause 16 liability is extravagant, then why can it not now, they having put this evidence before the court, be substituted with a liability at least to that which their own evidence shows would have been charged by a conventional hire company for the 12 days. So if they are to rely on this, the goose should be sourced as the gander. And in my respectful submission, therefore, even if they show that clause 16 is unreasonable in applying the help hire charge, it would not be unreasonable if, for example, it applied a charge equivalent to the £791 or the enterprise on their own evidence would have charged for a not dissimilar hire. My Lords, so those are my submissions on all of the issues apart from the Meadows Manchester Building Society. What I haven't done is I haven't engaged in, obviously from time to time I have respectfully criticised Lord Justice Dingaman's reasoning, but I haven't done it in a structured or methodical way. And the reason for that is simply...
All in your case.
Well, it's all in our case. And we do say, really, the submissions I've made, if they're right, then with great respect, the Lord Justice's analysis simply can't stand, and if they're wrong, well, then so be it. But it is in our case between pages 69 and 87. My Lords, I am going to ask Mr. Smiley to follow as I indicate.
There's no dispute that it is the 12 days higher.
No dispute. Yeah. There's one small wrinkle, which is the rate that was charged. Mrs. Armstead wasn't given credit for the fact that the total hire went over 28 days, which is why we've slightly decreased the claim from the pleaded amount. But I don't propose to get into that. Yeah, I'm grateful. Mr. Smiley.
Yes, Mr. Smiley, you've been cut down to 10 minutes.
My Lords and my Lady, I'm just going to make a little room. Yeah, that's all right. You will have seen from the judgment of the Court of Appeal that Lord Justice Dingaman's considered the twin cases of Manchester Building Society and Carnan Meadows at paragraphs 58 and 59, which I'll take you to in a little while, as a cross-check. So this was after he'd carried out his detailed analysis and provided his 5 reasons for finding in RSA's favour. It was not presented as an independent ground on which to dismiss the appeal. And so in a sense, my submissions are somewhat superfluous. But nonetheless, I will engage with them. Because the Court of Appeal did err, we say, in respect of its cross-check, and the analysis undertaken by Lord Justice Dingaman's in respect of the 6-fold test set out by the Supreme Court in those 2 cases reveals misconceptions. Given the time remaining, I will turn directly to the 6 questions as posed by the Supreme Court in those cases, and then address how each of those questions was answered, we say wrongly, by the Court of Appeal in this case. So if your Lordships and your Ladyship could turn to page 1348 of the bundle.
Do you accept that it was appropriate to be engaging in this exercise at all, or
My Lord has already anticipated a point. I do note that my Lords, Lord Burrows and Lord Leggett, may have, I won't say an axe to grind, but have a particular interest in that point. We obviously observe that those decisions were made in the context of professional negligence and clinical negligence. And we also note, and on this side agree with, the observations made by Lords Burrows and Leggett, particularly in the Khan case, at paragraphs 78 to 80 and 96. It is obviously the case that the Supreme Court, in its wisdom, or at least the majority, decided to go somewhat further than it absolutely needed to in respect of the way it restated the conceptual framework and purported, at least, to do so for negligence generally, rather than dealing specifically with the issue that was before it, which was the scope of duty in professional negligence and clinical negligence. So, to an extent, the 6-fold test is obiter and inapplicable here, but we say, in any event, that applying that cross-check, the answers should have been answered, the questions should have been answered in the affirmative. I won't read out each of the questions, but I'll then turn to, particularly in the short period of time available, I'll turn to the way those 6 questions were answered by Lord Justice Dingemans. And you'll find that at page 86 of the key documents bundle, page 134 of the full bundle. So the first question is actionability of the harm. Here, the harm is economic loss consequent on physical damage. That is actionable. And it can be contrasted with the examples of harm which is not actionable, which were given by the majority in the Supreme Court. For example, in Khan, there was reference to symptomless pleural plaques. In MBS, there was reference to personal upset or annoyance and diminished enjoyment of a person's property. Lord Justice Dingemans here at paragraph 59 says that the damages payable under Clause 16 are not actionable because Clause 16 is an internal agreement between bailor and bailee. And with the greatest respect, that simply does not make sense as an answer to this question. It appears to rest on his internal arrangement, his res inter alios acta analysis, which Mr. Williams has already addressed, and rested seemingly on a misunderstanding of the Winkfield. It's dealt with fully in our written case at paragraphs 22 to 29, but put shortly, if the economic loss of this nature, i.e. arising from contractual liability to a third party, but consequent on physical damage, was not actionable, then cases such as Network Rail and Emler and Hall would not have been decided in the claimant's favour. Then the second question, scope of duty. Here, the harm in question is a contractual liability owed under a hire agreement as a result of damage to the hired vehicle. And your lordships and your ladyship can see at paragraph 59 that Lord Justice Dingemans held that the loss of the use of the Mini Cooper motor car as it was being repaired fell within the risks of harm which RSA's insured driver had a duty to take care, but the quantification of that loss in clause 16 was not within the scope of the duty. And we obviously agree with the first part of that dictum, but take issue with the second. And we note that this question, this entire question, the scope of duty question, is ill-suited to the road traffic sphere. It's evolved in the professional liability context, where pure economic loss without physical damage is common, and where even in the clinical sphere, there may be physical damage. The doctor's assistance is often directed at a specific issue, and so a specific harm. The purpose of the duty to take reasonable care on the road, by contrast, is to prevent, one, physical injury, and two, consequent financial loss. And of course, you have a legal obligation as a motorist to insure against both the former and the latter, which might well be thought to shed some light on the scope of the duty. We say the method of quantification is not a relevant or appropriate basis to hold that the consequent financial loss suffered by Miss Armstead here is outside the scope of the duty. That might be relevant at the remoteness stage, but it is not an appropriate distinguishing factor when considering the risks which the duty is intended to guard against. Given the time, I won't go much further than that. I refer on the scope of duty. What I do refer to is a passage from the Network Rail judgment, which Mr. Williams has already taken you to. It's Lord Justice Moore-Bick at paragraph 101, page 758 of the bundle. And within Khan, the majority said at paragraph 62, page 1358 of the bundle, right at the bottom, it is not therefore relevant to its applicability whether a claim is characterised as one for economic loss consequence upon foreseeability. The foreseeability of such unrelated disability is in no sense determinative of the question of the scope of the duty of care. That is because, over the page at page 1360, the scope of duty question depends principally upon the nature of the service which the defendant has undertaken to provide to the claimant. And the judge goes on In cases where there is a duty to take care to avoid causing physical injury, I'm struggling to find it. Yes. It's at the top of page 1359. That distinction may, on the other hand, be relevant to the outcome of the application of the principle, because in cases where there is a duty to take care to avoid causing physical injury, the economic loss consequent upon that injury will generally be within the scope of duty and will be recoverable if it is not excluded by the legal filters, which we've described in our discussion of the sixth question, which just goes to show that this issue of whether the economic loss consequent on physical damage is recoverable is best answered at the remoteness stage, we say, as opposed to the scope of duty stage. Just as in Network Rail, economic losses arising from loss of revenue quantified by contractual, in that case very complicated contractual mechanisms, were within the scope of the duty, so here Miss Armstead's relatively simple contractual liability is within the scope of the duty. I can deal very briefly with the third question. This was the question of breach, which is admitted by RSA in its defence. And we do pause to observe that rather oddly, Lord Justice Dingemans did not want to, or seemingly did not, in any event, answer this question. The answer must be yes. So we move quickly on to the fourth question, factual causation. Application of the simple but-for causation test leads to the clear answer yes. This is not one of those unusual cases where the but-for test is inadequate. We note that in Khan at paragraph 46, there's reference to the cases where, for instance, there's multiplicity of wrongdoers or sufficient causes, and that's not this case. So when Lord Justice Dingemans held that the reason why the Mini Cooper motor car was not available for hire was because it had been negligently damaged by RSA's driver, but Miss Armstead's liability under Clause 16 arose because of the terms of the help hire agreement, that second part of the judgment is plainly wrong, because the proximate cause of Miss Armstead's loss here, the liability to help hire, is the damage to the vehicle, and RSA had never contended otherwise. And if it were the case that the contractual arrangement was the factual cause, then it would have defeated the claims in Aimler, it would have defeated the claim in Network Rail. And here, in this very case, it would have defeated the claim in respect to the repair costs. I note, Lord Briggs...
You're in danger of grabbing a bit of your leader's reply time.
I am, and I'm turning to the fifth and final question that I'm dealing with. The remoteness issue was already dealt with by Mr. Williams. And on the fifth question, the duty nexus question, this flows from the scope of duty question, the second question posed by the majority. And we say that, and I'll just read it out, that the example given in Khan at paragraph 47, which deals precisely with a motorist who damages a pedestrian in that case.
Page number?
It's page 1355. That is almost on all fours with the current case. Here, the driver has carelessly injured the vehicle in Miss Armstead's possession. He has breached the duty of care which he or she owes to the pedestrian to avoid inflicting physical damage to that vehicle. And the only difference here is that the economic damage is not the loss of wages, which is the economic loss referred to in Khan, but rather the liability to the hire company. So we say that Lord Justice Dingemans erred at each stage of the six-fold test. Unless I have anything further I can assist with.
Thank you very much, Mr. Smiley. Now, Lord Mark.
My Lords, my Lady, I will, if I may, please address the grounds of appeal in the order in which they appear in the permission to appeal application. That's on page 17 of the bundle. Before I start, may I apologise for the fact that I'm using old-fashioned hard-copy bundles. We had some difficulty with the hyperlinking, but I hope it won't hold us up.
Well, Marks, we're very used to advocates in the front row using paper bundles.
My Lords, that should shame the front row.
It's paper bundles in the front row, laptops in the second row, and increasingly laptops up here. But we have a sort of mixture.
Well, my Lord,
Don't feel
thank
in
you.
any way troubled, so long as you've got the electronic page.
I have the electronic page numbers, and I shall use this. May I start with a preliminary observation? This is not the usual case for the credit hire litigation with which this and other courts have become so familiar in a rather unwelcome way, as many judges have commented. It's not a case of the owner or possessor of a car damaged in an accident claiming damages from the negligent driver for the cost of hiring a replacement. That's the usual credit hire case. Here, Ms. Armstead brings her claim in negligence, and Mr. Williams is quite right to point that out, as the bailee of a credit hire car against RSE, whose insured driver, whose name I take from the pleadings to be Mr. Gelewski, negligently damaged it, and this is not a claim in respect to the cost to her of hiring a replacement car, but it's in respect of a contractual liability to the credit hire company, which rented the car to her following her first accident. And that's what Mr. Williams has called the Clause 16 liability in shorthand, and I'll adopt that as well. So the liability she had undertaken to pay the credit hire company was for the full credit hire charges that they would have charged for the time that the replacement car they rented to her was off the road during the repairs. And that was, as we saw from Clause 16, in the event that she returned the car damaged, but also in the event that she failed to return it in accordance with Clause 9, or that the hire car had suffered a mechanical failure which wasn't properly notified to help hire. So Clause 16 goes wider than simply a damage case. And Mr. Williams is right that that was limited to a maximum of 30 days. We do not suggest that all consequential loss is irrecoverable, and we've never suggested that. We accept that the cost of repairs is recoverable, and we have also accepted throughout that loss of use is recoverable. And we've never suggested that it doesn't follow from the Winkfield, exactly as Mr. Williams suggests, that the possessor of a car as bailee is in the position of the owner in terms of what can be recovered during the time of the bailment. However, that does not remove the requirement that for consequential loss to be recoverable, the loss has to be consequent upon the physical damage. And I take the point made by Lord Burrows in argument with Mr. Williams that there may be a difference between consequent and directly consequent. But for the purposes of our argument, I'm not sure that that matters. What does matter is that our submission is that the incurring or the arising of the Clause 16 liability, and it's important that Clause 16 was part of the contract which was entered into before the accident, the arising of the Clause 16 liability follows from the nature of the contract and not from the physical damage itself. Certainly,
do you seek to uphold Lord Justice Dingman's apparent conclusion that, as a matter of fact, it wasn't a consequence of the damage, the liability?
My Lord, I'm not sure whether it whether it matters whether that's seen as a matter of fact or a matter of legal analysis. We would prefer to see it as a matter of legal analysis, because we say that as a matter of law, the contract and the form of Clause 16 was the cause of the liability. And that's particularly the case because the liability has no connection. The nature of the liability and the extent of the liability has a connection only with Ms. Armstead's contract with help hire and doesn't represent loss flowing from the physical damage.
I'm struggling with that submission. How can you say that a clause that's triggered by damage to the car is not something that's consequent on or has no causal connection with the physical damage? I mean, Clause 16 wouldn't be triggered without the physical damage, would it?
That I'm accepting, but when you come to the question that Lord Dingemans found important and that we suggest is important and is crucial, of the assessment of what loss follows, if it is the case that the loss that follows is only the contractual liability, that is to pay the full retail charge-out rate, the credit hire rate, under the contract, which is what's chargeable under Clause 16, and that does not represent the loss to either Ms. Armstead or help hire, because in reality it's accepted that this is help hire's loss. If they cannot show and never could have shown that absent the contract they were suffering that loss, then the loss is not consequent on the physical damage.
How does that work in the context of a case like Network Rail, where in practice it would always be as near as damn it impossible without having a year and a half's worth of litigation to show what real loss Network Rail had suffered through a bridge bash, so they dealt with it by a pre-existing contractual formula in Schedule 8 of the track access agreement?
My Lord, that's absolutely right, and I'm going to come to Network Rail in some detail and to passages in Lord Justice Pill's judgment which weren't read to you, which we say makes it absolutely clear that the existence of a contractual liability is not enough. And the reasoning behind that is that the tortfeasor, the negligent driver in this case, was, and indeed in Network Rail, was a stranger to the bargain between Ms. Armstead and help hire. So,
but that didn't stop the bridge bash, to which the person who bashed the bridge bash giving rise to the ability of Network Rail to recover under Schedule 8. Now, the person who crashed into the bridge was just as much a stranger to Schedule 8 as the driver in this case is a stranger to Clause 16.
My Lord, that is absolutely right. However, the point that I propose to make and will develop is that there were two elements to the requirement for liability to affix. First, that there was a contractual liability, and second, that contractual liability represented a reasonable and genuine assessment of the actual loss sustained by the train operating companies. And what Lord Justice Pill said is that it would be simplistic simply to go from the point that there was a contractual liability to the stage of saying liability follows from the fact that there is a contractual liability between, in this case, Ms. Armstead and help hire, to the conclusion that therefore the amount of that contractual liability is recoverable to the stranger, the tortfeasor, from the stranger, the tortfeasor.
Well, you'll take us back to that passage, no doubt.
My Lords, I will, and it is
based on the wagon mound, I seem to recall.
I'm sorry, it's based on?
The wagon mound.
Yes. Well, tangentially. It's certainly important that the wagon mound is authority for the proposition contended for by Mr. Williams and agreed by us, the damage of the kind that has been suffered is foreseeable. But it's also important in this context, we say, because it's an indication that it's not damage of the kind that is suffered if it doesn't relate to the actual loss, which is the costs incurred by help hire as a result of the accident. And that is why, and I'll come back to this, that is why it is so important that help hire have a stock of cars. And the recorders so found, and that's common ground. If help hire had a stock of cars, and their revenue depends on renting out some of them, generally since it's a credit hire specialist company, some of them at credit hire rates, but they have a stock sitting in their garage, unrented out, then they do not suffer the loss. And this is what Lord Justice Dingemans found, at least for part of the time, when one car is off the road or under repair. That doesn't represent a loss of the entire retail credit hire rate. And absent the nexus between the damage and the loss of the kind that they claim, that is pure economic loss. And that brings into question the next conundrum that we say is important, which is in any case, it has to be proved that the loss claimed is a reasonable assessment of the damage. And if it's not a reasonable assessment of the damage, then it's not foreseeable. Now, that is a matter which was alluded to by Mr. Williams in his submissions, but it is specifically conceded in his written case. And we say that the reasonable assessment requirement is a requirement of foreseeability. And although as a matter of legal analysis of the wagon mound, it may be distinguishable from the question of remoteness. It seems to be common ground between us, and we would suggest rightly so, that remoteness and foreseeability are, for this purpose, very closely connected. Reynolds, if I could...
So it's central to your submission that help hire is effectively in the position of not earning other revenue if a car is damaged, because you say there's a surplus of cars, there's always another car sitting there, which will be more than enough.
Yes.
To cover with at no cost to help hire, or
exactly.
at what one might call the capital depreciation and that sort of example from non-revenue earning.
Yes, that's the that's the ratio of the Beechwood decision. But that's the loss if you have revenue earning assets that aren't earning revenue, but they're sitting in a garage.
Who has the burden of proof on foreseeability and remoteness of damage?
The burden of proof is on the, this is in the normal case, is on the hirer to show that it is reasonable to hire a car. The burden of proof on mitigation, if you're saying you should have mitigated, that's generally on the defendant, and that I accept. But in this case, it is for them to show, it is for the claimant to show the claimant's loss. So the burden of proof on this issue, that they have suffered a loss, and the assessment of the loss, the burden remains upon the claimant on ordinary first principles.
Well, the claimant has a loss just from the liability, but your submission is that if that liability exceeds the loss of the third party, it's not recoverable by the claimant. Is that right? It's not. Yes, by the claimant from the defendant.
Yes, but there's another glitch to that, which is that Ms. Armstead herself neither claims for loss of use nor sustained loss of use.
No, her claim is that she incurred a liability. And
her claim is she... Yes.
And that's a loss.
I mean, she had two alternatives, didn't she, after the crash? She could have taken the car off the road and had it repaired so as not to trigger clause 16 at the end of the hire period, in theory. Or she could go on driving the car and hand it back damaged and pay up under clause 16.
Yes.
Is that fair?
She could have repaired it herself.
Well, obviously not.
Yeah.
Physically.
I mean had it repaired by another repairer and returned it, and then there'd have been no loss, no damage, yes.
So if she had taken it off the road and repaired it herself, she would be paying hire charges at the credit hire rate to help hire for nothing, no use of car because it's off the road.
Well, I'm not sure that's right if you look at clause 16. It's page 189.
No, I'm saying if she avoids clause 16 by...
Well, I'm not sure she can.
Oh, I see.
It'd be very surprising if the hirer would allow...
Well,
would be allowed just to take it to any old garage, I suppose, isn't it?
Yeah, maybe so.
If I can show you...
An answer. Let's have a look at it.
If I can show you in the remaining moment or two. It's page 189. So, clause 16, you will on demand pay to the lessor an amount equal to the daily rental rate specified overneath in respect of damages for loss of use for each calendar day. And the important point is they're claiming that they represent damages for loss of use. And our point is that if there are other cars in the garage, they are not damages for loss of use. For each calendar day or part of a calendar day where the hire vehicle is unavailable to the lessor for hire because you've not returned it, or the hire vehicle has suffered a mechanical failure, except where you've complied with clause 22, or the hire car has been damaged. And clause 22 is you shall notify the lessor immediately should any damage or fault occur to make the hire vehicle unroadworthy, or if continued use is liable to cause further damage, and shall not in any case use the hire vehicle until such damage or fault has been repaired. And clause...
That didn't apply here, presumably.
Yes.
It wasn't rendered unroadworthy.
Yes. And clause 14 is about returning the car in the same condition. I'm not sure that
I don't see that rules out my Lord Briggs's
suggestion.
Situation. It would have been open to her to repair the car and carry on paying the hire charge, and then return it at the end of the period.
There's a reference in 23. I don't know if it covers
I was just going to come to that.
I'm sorry.
So, well, 23, the lessor will be responsible for and will bear the cost of any mechanical breakdown not attributable to your act, neglect or fault. And such neglect or fault would include, but not be limited to, your failure to maintain adequate lubricant levels, provided the lessor's consent is obtained before the repairs are carried out, and they're carried out at a repairer of the lessor's choice. The extent permitted by law, the lessor should be under no liability whatsoever for any damage, loss, consequential loss, cost, charge, or expenses arising out of or attributable to any breakdown unless this results from its negligence or breach of contract. So I'll think about it, if I may, over the adjournment at that point, because it's slightly...
You're not suggesting, as I understand it, that Mrs. Armstead wasn't bound by clause 16 to pay what that clause required. In other words, she wasn't. It's not being suggested by you, is it, or is it, that she's got no contractual liability?
No, that's not being suggested. But it's very important not to take the extent of that concession too far. She has entered into that bargain which involves her clause 16 liability. The question for the court in this case, though, is whether that liability is recoverable from the negligent tortfeasor merely because it exists as a liability as between her. And it's my Lord's point about an improvident bargain. Of course it is right that parties may enter into improvident bargains. But the point of the internal arrangement finding, cutting it short when we come on to the direct submissions that we make and the grounds of appeal, Lord Justice Dingaman's point is that that is an internal arrangement under the contract between the bailor and the bailee, helper and Ms. Armstead, and is not therefore recoverable, is not for that reason alone, recoverable against the negligent tortfeasor. That is where Lord Justice Pill's condition comes into play, that not only must you have the liability, you must also have an assessment of the liability that says it's reasonable. We say that clause 16 is not reasonable in the sense of giving rise to recoverability against the tortfeasor.
You mean not reasonable in terms of the amount payable under it?
Yes. And the kind of damage. Because the kind of damage is the retail charge-out credit hire rate for a chattel that they never established had actually lost that use. And that's why my answer to my Lord Richards on the question of where does the burden of proof lie is that the burden of proof lies on the claimant to show the loss, and the loss is not the loss of revenue that they might have earned had they been in a position to, and prove that they would have, hired out the money to somebody else.
Sorry, so are you suggesting that in clause 16, the words equal to the daily rental rate, we have to start looking at whether the daily rental rate was in any sense a loss to help hire?
The daily rental rate is the defined rate, which is the retail charge-out rate.
What I'm suggesting to you is, or what I'm putting to you, is it part of your case that it matters whether or not help hire has itself suffered a loss of use rate equivalent to that rate?
I think it is part of your case. That's what I understand you to be.
Yes, it doesn't exonerate Ms. Armstead from the liability under clause 16 to help hire. It does render that liability insofar as it doesn't represent actual loss consequent on physical damage.
Right.
It prevents her from recovering that against
the tortfeasor. The practical consequence in relation to something like clause 16, which charges the credit, what you call the credit hire rate, is that it would be incumbent upon help hire in any case where its hirer wanted to sue the negligent driver for the clause 16 loss to show that its pool of available vehicles was empty during the whole of the relevant period.
Well, not necessarily empty, but yes.
Well, empty in the sense that
they've got to show the loss.
Yes.
And
they didn't have a substitute.
They didn't have a replacement vehicle.
Yeah.
When one comes to look at what Lord Justice Dingaman said about this, he said, well, I think he used the words overwhelmingly probable, that help hire would not have been able to rent it for all of the time, probably for part of the time they wouldn't, and an analysis, or at least a table showing help hire's rates of use of vehicles in their stock would have been helpful. Yeah. So it wasn't something that was difficult.
There was absolutely no evidence to base his statement on, was there?
Well, there was a finding by the recorder that there was a stock of vehicles and the Mini was just one of its hire car fleet.
What was the evidence underlying that?
May I ask Mr. Tannock?
Yeah, well,
let's do that over the...
Yes.
I'll tell you that.
Just ask before we go to adjournment. Mrs. Armstead, on the face of it, is acting entirely reasonably in going back to help hire and having the liability that she has incurred. I mean, she's not acting unreasonably in the face of what's happened to her, I think you would accept. She is not acting unreasonably.
She doesn't act unreasonably in doing what she's got to do under the clause 16. That's right, yes.
So
vis-a-vis help hire, yes.
So there's no problem about her having failed in relation to any duty to mitigate or anything of that kind?
No.
You could not have mitigated her loss by any other conduct?
Once she had the clause 16 liability, that must follow.
Right. So everything turns, although it doesn't appear to be that she's ruled out by any duty to mitigate problem, everything is turning here, is it, on whether or not it is too remote, not foreseeable, that she is incurring a liability that is regarded as unreasonable under the contract. That's your proposition.
It goes further than that. The question is whether it is a reasonable assessment of help hire's loss, because it's common ground that she's not sustained any loss. Indeed, this was all after the hire, so her possessory title has passed by the time that...
That's all a remoteness question, is it?
The reasonableness is a foreseeability and remoteness question, and it's also a precondition of recoverability, that it's a reasonable loss.
I'd like to see some authority that tells us that remoteness ever turns on questions of reasonableness by the claimant.
Well, let's do that after the short.
Yes.
At 2 o'clock.